Morning, Ms. Strickland.
Good morning.
Are we ready to get started with the magistrate docket for the adults today?
Yes, Judge.
All right, before we get started, ladies and gentlemen, you're here today for first appearance. Today's your opportunity to be advised of the charges for which you've been arrested. Today is also the day that this court will determine whether or not there's probable cause that a crime was committed in this case. The court will hear any argument that's raised as to probable cause. And then the court will determine what bond is appropriate. If bond's been previously set, the court will determine whether modification is appropriate. And if bond needs to be set, the court will determine the appropriate bond. For purposes of first appearance today, at this time, I am going to appoint the Public Defender's Office to represent all of those individuals presently in custody. If you wish not to have the Public Defender representing you at this appearance this morning, please let Ms. Strickland or myself know that you've either hired a lawyer or that you intend to hire a lawyer and do not wish the Public Defender to speak on your behalf. There may be limited opportunity for some of you charged with municipal ordinance violations or misdemeanors to resolve your cases. That'll be up to the discretion of the court, taking into account the input of the state, of course. In the event that you are given the option of resolving your case, I will advise you of your rights, but please keep in mind that if you're currently on any kind of release, whether it be probation, parole, or any other kind of conditional or supervised release, that a plea to any offense could result in a violation of that release. You also have the absolute right during the proceedings today to remain silent. Please keep in mind that anything you do say is being recorded and may be used against you at further court proceedings. All right, we're going to go ahead and get started this morning. I'm going to go off calendar, or not off calendar, but I'm going to jump ahead to Awins Lesueur, which appears, I believe, on page 20 of the magistrate docket. 21?
21, Judge.
And that Mr. Lesueur does have a private lawyer present in the magistrate courtroom.
Good morning, Your Honor.
Judge, I'm just going to step out for a second since he has a private attorney. I'll be right back.
That's
Is
fine.
that okay?
Yep.
Do you want me to leave this on for
In
so
the
he
event
can?
that he wants to say anything, please leave. You can go ahead and leave the microphone on.
Okay.
All right.
Good morning, Your Honor. James Lewis on behalf of Awins Lesueur.
All right, court, Mr. Lesueur, having been arrested on a arrest warrant, the court is going to make a finding that based upon the signing of the arrest warrant by Judge Bailey, that there is probable cause. This is a first punishable by life?
No, it's not punishable by life, Judge. And that's why I'm arguing that he's entitled to a bond as a matter of right.
Oh, because it's an attempt as opposed to just a standard second degree.
Yes, sir, and the firearm is not alleged. It's not even punishable by life, so I'm asking the court to set a reasonable bond in the case. I understand the court has absolutely nothing as to the facts of these circumstances before it.
Correct, Your Honor. That's why the state would be asking just for a 24-hour reset to get the affidavit from the clerk's office to get the factual allegations surrounding surrounding the offense. So that way, if it could be a PBL, I would like 24 hours just to make sure that it's not.
As I understand, the allegations have to do with him hitting somebody in the head with a bottle at an adult entertainment club on Broward Boulevard. Now, I will tell you later, this is part of an ongoing investigation. That person was later apparently shot by another unknown person in that same club later in the evening.
Well, the question at this point is, do you have any objection to the state's request to reset this for 24 hours?
I'd ask that the court set a bond today, Judge. Again, I think he's entitled to bond.
I don't think he's not entitled to a bond. I mean, I think the only basis that the court can hold him is under Florida Rule of Procedure 3.132. Since he is charged with what's under 907.041, a dangerous crime, the state's indicating that they're going to file a motion for pretrial detention. The court has the jurisdiction to hold him for up to 72 hours to give the state an opportunity to file a pretrial detention motion if there are exigent circumstances. But unless the state is going to, on the record and in good faith, indicating that they're going to do so and indicate that there are exigent circumstances, I think the court is obliged constitutionally to set him a bond.
Your Honor, I wasn't going to do that. I was just asking the court to reset it for 24 hours, which the court can do.
Under what authority? This is not a situation where there's 24 hours to perfect probable cause. I'm finding probable cause. It's just the appropriateness of bond. Can you show me somewhere in the statute or in the rule where the court has the discretion of just hold somebody after a finding of probable cause on an otherwise bondable offense. The only thing I'm aware of is if the state, in good faith, determines that they're going to be filing a motion for pretrial detention. If there's somewhere else you want to point me, I'll be happy to look at it, but I'm not familiar with any other provision of law that prevents me from setting a bond today. Now, of course, the nature of the charge as well as any other factors I would be taking into consideration. And if I ultimately conclude that there's no reasonable conditions of bond that would justify release, then I could do that, but I have to at least consider the setting of a bond.
Understood.
So anything the state wants to provide at this time other than the nature of the charge?
Yes, Your Honor, his criminal history, 2008 false name, 2008 driving while license suspended, 2008 possession of cocaine with intent, 2010 possession of cocaine, 2010 possession of cocaine, 2010 disorderly conduct, 2011 resisting without violence and DWLS, and 2014 possession of a firearm by a convicted felon and violation of driver's license restrictions.
And at least some of those cases I've represented him on, and I know that they did not end up in convictions. So
Those were all convictions, actually.
I'm not,
That's what I'm getting from the state. We can
All right.
test that certainly. Anything else the state wants to present?
Yeah, Your Honor.
Defense?
Judge, he's a lifelong resident of Deerfield. Again, I know the court's a little bit blind here because you don't have any of the facts and circumstances of this offense, but I'm asking for a reasonable bond somewhere, I think around $10,000. If the court thinks that pretrial is necessary in the case, certainly we can do that until such time as maybe we sort this out, but I'm asking for that kind of a bond.
Do you have a lawyer, Carlos? Señor. Español.
All right, I'm going to set bond
Don Carlos, ¿tienes abogado?
$25,000. I'm
Yo
not
trabajo
going
con
to
la
go for pretrial.
Your Honor, just for the record, that's over state's objection.
Thank you, Judge.
Thank you.
¿Dónde? Permítame, debe ser que esté con favor. Right here, okay. Jim Lewis.
Ms. Strickland?
At my own, but Jim Lewis.
Yes, sir.
All right, we have first up, we have Penny McClatch.
She's coming up.
All right, Ms. McClatch, you're charged with battery of a domestic nature. Any argument as to probable cause?
Ma'am.
All right, this time the court's going to find probable cause. As to bond, state.
Judge, would you consider pretrial release on Ms. McClatch?
I'll consider everything. State, what's the state's position as to bond?
Your Honor, I'm still looking up her priors. Give me 1 minute.
Este espacio todo, nombre, dirección y teléfono.
And I don't have that she has any priors.
All right.
Your Honor, the state would recommend a $500 bond.
Judge, Judge, we can't hear what the state attorney is saying.
It's not the
I
state
don't know if
attorney,
it's-
it's your
Oh.
compatriot who's speaking now. The state attorney has asked
okay.
for a $500 bond.
Judge, based on the facts of this case, this doesn't seem a case that will even be filed.
Is she living with the alleged victim?
No, Judge.
All right, this time I'm going to go ahead and I'm going to, based on the lack of violent priors, ROR her with pretrial release. No contact with the victim, direct or indirect, for the time being.
Thank you, Judge. Okay, we have to report to pretrial. You don't just...
Oh, wait, what did I just say? Okay, yeah, no, it's in the,
Thank you, Judge.
All right, next I have Isaura Orsina.
Yes, Judge, she's coming up.
Or any argument as to probable cause? All right, court's gonna find probable cause. I'm sorry, Mr. Cena, you're charged with battery of a domestic nature. Court's gonna find probable cause as to bond state.
Your Honor, the victim's present.
How you doing, sir?
Give you a chance, hold on.
Okay.
I asked for at least pre-trial release with an income monitor. She is alleged to have hit the victim over the head with a frying pan. I don't have any priors.
Judge, I don't know if you would consider pretrial release without a monitor. She has children. I don't believe she has any prior record. I don't know what the victim's going to say, but obviously the victim's there, so if you want to hear what he has to say. She seems very remorseful in court this morning and is very upset. I don't know how much she's going to be able to talk.
All right, sir, you want to raise your right hand?
Yes. Kevin Hebert, Hebert.
All right, Mr. Hebert, you're the alleged victim in this case. Is there anything you want to say to me with respect to the setting of a bond? As to
Yes,
Ms.
sir.
Racina?
She has 3 children at the house. She needs to be home to take care of them. If you could find it in your heart to give her ROR, it would be greatly appreciated.
Are you living at the home with her?
I am.
My concern would be ordering contact. If I ordered no contact, she would not be able to come back.
I would rather you didn't do that. We're trying to work it out to find her a place to stay. If you could just give it this one time, it'd be greatly
Let
appreciated.
me ask you, is there any history of violence between the two of you?
No, sir.
Are you concerned for your own safety? Because if I don't order no contact and allow her to have contact with you and something else should come up, I mean, I want to make sure I have here on the record you standing before me telling me that you're not concerned about it and that you're okay with her coming back to the house. I mean, she's alleged to have hit you on the side of the head with a frying pan.
Yes, sir.
You know, that may...
I'm okay with her at the house. I'm okay with contact. I'm not in fear for my safety.
State any questions?
No, Your Honor.
All right, I'm going to go ahead and ROR. I'm going to put standard pretrial release, but based upon the victim's testimony, I'm not going to order any no contact.
Thank you, Judge.
All right.
Okay, thank you.
All right, sir.
Thank you.
Thank you.
Good job.
All right, next up I have Becky Nichols.
North Broward?
All right, good morning, Ms. Nichols. You're here today for a violation of probation warrant on case number 13-15812-CF10A, issued by Division FV. It's a no-bond warrant. I'm going to go ahead at this time and hold you on the warrant. Anything else from the state or defense?
Judge, if you could just let her know, it says that there is a court date already of 12/2, so she'll be going to court Wednesday.
Yeah, I'll let her. I'll make sure to note that. Anything else you want to add before I finish with Ms. Nichols?
No, Your Honor.
No? Okay, Ms. Nichols, you're going to be in court before your division judge on December 2nd to address this matter, all right?
Thank you.
Thank you. All right, next I have Nicholas Mamonville. All right, Mr. Mamonville, you're charged today with battery of a domestic nature. Any probable cause argument from the defense?
No, Judge.
No argument? All right, court's going to find probable cause. As to bond, state?
Your Honor, the defendant has a juvenile record and also a criminal history consisting of burglary.
Armed burglary?
Judge, he's
Not
45. What, a juvenile record? I'm confused.
Burglary
His birthday's
and possession of
1970.
burglary tools.
Hold on, Mr. Strickland. The burglary and possession of burglary tools, how old are those?
Those are from 04.
2004, okay, go ahead.
They can't be him if they're a juvenile record. His birthday's 1970.
Well, no, I think
He
they're
would've
going
been-
over his adult record now, is that correct? Or are those
Correct, Your Honor.
That's
Oh,
correct?
okay. I'm sorry.
Yeah. See, they mentioned they have a juvenile record, but I recognize his juvenile record would be some time ago. But as an adult, it seems like there's a 2004 burglary and possession of burglary tools. What else?
That's all I have, Your Honor. I don't know if
Those?
pretrial has
Judge-
anything else.
Judge, Mr. Mammonville has indicated to me that he does not have any prior record. And I can't verify anything, but he told me earlier this morning, and when he's listening this morning, he's saying no, that's not him. I mean, I know it's a unique name, but
Well, you can contest that when it gets to division.
Judge, pre-trial record at CIC, and we don't see a prior history.
All right, seems like there's a conflict there. Anything else in the state as to bond?
No, Your Honor.
Judge, are you considering that the state's saying he does have a prior record, or are you considering that pretrial is saying he does not
I'm
have a
considering
prior
I'm
record?
considering both and recognizing that there's a conflict there. I can't make a determination as to what is or what isn't unless we take some fingerprints.
Is the state's a NCIC or is the state's a BCCN?
Give me a minute.
I mean, is it a Broward record or a national record?
This is from Florida CCIS, and I stand corrected. He's the listed victim on this, but he's showing up on his criminal history.
Oh, see. That's,
Okay, so he's a victim. Okay, that's
right,
not
but still
correct.
showing up as his, so he may want to eventually look to get that taken care of. All right, but that being said, all right, so it sounds like there's no prior criminal history. What position does the defense take in terms of bond?
Judge, would you consider pretrial release? He has a job. He has no prior record. He is 44, 45 years old. I don't know if you would consider standard pretrial. I don't know. Is there anybody present? Is the victim present? I can't tell.
Anyone here? Is there a Michelange Moise present? No.
And Your Honor, victim advocate stepped out. I don't know if they had anything to add.
Does it
He's employed as. Oh, I'm sorry.
I was going to ask about his financial circumstances. Go ahead.
Judge, he does have children. He does have a job. He works as an accountant. I don't think he has a great deal of money to post a bond. That's why I was asking if you would consider pretrial release.
Is he living at the home with the victim?
No. He indicates no.
Where are the children?
Where are the children living? With the mother?
With my wife.
The children are living with your
The
wife.
victim is not my wife.
Oh, I'm sorry. It says the victim is not his wife.
Just the father, just the mother of some of his, or at least one of his children.
Yes.
Yes. Okay.
One of them. Yes.
And he doesn't.
So you do not live with the victim.
No.
He does not live with the victim. I don't think he lived with the victim at the time either.
No.
Alleged victim.
All right, here's what I'm gonna do. I'm gonna go ahead and set bond the amount of $500. Add a condition of pretrial release with no contact.
Here. You're gonna have to post the $500 bond.
Now the middle guys, remember, do not walk this way.
All right, next up I have Darwin Brooks. All right, Mr. Brooks, you're here for domestic stalking. Any argument as to probable cause?
Judge, Judge, I don't know if they were able to verify the restraining order out of New York City, but it appears that from the PC, it appears that the victim and the defendant were living together. So I don't know if the victim had gone and taken it away or it became inactive. I mean, there's nothing in the probable cause that says that they confirmed.
Oh yeah, it does. It says a routine check revealed that the routine teletype revealed that there's an active restraining order out of New York City.
Y'all need to talk, man.
Inactive
He-
for over a year ago.
The defendant seems to think it has been inactive for over a year. They've been, according to the PC, living together. I'm not saying he told me they're living together, but the PC has them living together.
Yeah, no, I see that. But the PC also says there's an active warrant. So based upon the probable cause affidavit, I'm going to find probable cause. As to bond, state.
Your Honor, I don't have a criminal history. I don't know if pretrial does.
Yes, sir. 2006 financial instrument fraud, guilty. Also in 2006 misdemeanor theft conviction. In the year 2014 criminal mischief and assault, third degree, no disposition. And in the year 2003 passing that chase, guilty and arrest.
All right. Mr. Strickland, anything else you want to add?
Just that Mr. Brooks indicated to me that he does have a job. He works at Walgreens on 15th Avenue, and that in 15th and Federal, Fort Lauderdale. That he had, I know it's not to discuss the facts of the case, but he had indicated he didn't even realize the restraining order was still in effect. There's no indication that there's current violence or current problems with the alleged victim or the alleged person that the restraining order is against. I don't know if you'd consider pretrial release.
Is David Kuznitsky here? No? Does he have a place to live other than with Mr. Kuznitsky? Because I mean, if they're right that there's an active restraining order, if he goes back to the home, he's just going to violate it again.
He does indicate he has a place to live, and he's also a veteran. He was in the U.S. Army for 8 years. When did you get released?
2006.
He was released in 2006, and he indicated to me he was honorably discharged.
All right, at this time I'm going to go ahead and ROR him with just standard pretrial.
Thank you, Judge.
Listen, Ms. Strickland, I'm not going to order, based on the allegations in the probable cause affidavit, Mr. Brooks, come on back. I'm not going to order no contact because I don't see any reason to order no contact. But if there really is a restraining order in effect, if he has contact, he's just going to be violating that restraining order again. So he needs to, before he has any contact with Mr. Kuznitsky, he needs to go get some confirmation or some paperwork from New York showing that that restraining order is no longer in effect. Not only will it help him if he wants to have contact with Mr. Kuznitsky without any further criminal implications, but may also assist with the resolution of this particular case. So.
Okay, thank you, Judge.
All right.
Understood, sir.
Okay, thank you, Judge.
All right, next up I have Nixton Wallace.
He's coming up, Judge. There's a no bond hold for a misdemeanor violation.
All right, Mr. Wallace, you're here today regarding a violation of probation in case number 1320461 MM10A. It is a warrant signed by the division judge for no bond. I am at this time going to hold you no bond pursuant to that warrant. You do have a hearing scheduled on this matter, which is going to be set in the division.
Judge, is there a court date set yet?
There's not one on my sheet that I see,
Okay.
but I'll ask the clerk to go ahead and set this with some priority since he is being held no bond.
Okay,
All right?
thank you, Judge.
Thank you.
Hopefully you'll go to court this week. Okay, sorry about that.
All right, next up I have Timothy Locken. All right, Mr. Locken, you're charged with domestic battery by strangulation. Any argument as to probable cause?
No argument, Judge.
All right, court's going to find probable cause as to bond state.
Your Honor, he has a criminal history of 2005, a possession of controlled substance that the court declined to adjudicate, in 2011, burglary of a conveyance and battery. Based on that and the facts of the case.
Is it a burglary with a battery or burglary
No, Your
count
Honor.
2 battery?
Count 2 battery.
Okay.
Is there a disposition on that case?
Adjudication withheld.
It was withheld. Go ahead. Anything else from the state?
Based upon that, the state would recommend a $1,000 bond and pretrial.
Defense?
No victim contact.
Judge, he currently has a job as a server at a Steak 954 in Fort Lauderdale. Did pretrial interview him to see whether or not he qualifies for pretrial? I would ask if you'd consider standard pretrial.
Albert Joseph.
Judge, he was interviewed. We do not recommend domestic.
Hi, Albert. You boy. Are you gonna hire on? Do you want something to
All right, this time I'm going to go ahead and set bond in the monetary amount of $2,500.
You can post.
No contact with the victim, direct or indirect. All right, next I have Evan Blake.
Take anything?
No, you don't take anything with you.
Please try and find me.
Oh, I see. Okay. Sorry. Taking the pretrial orders. All right, Mr. Blake, you're here today charged with aggravated battery on a pregnant victim as well as tampering with evidence. Any argument as to probable cause?
No argument.
Our court's going to find probable cause. As to bond, count 2's already set at 1,000. As to count 1 or any modification on 2, state.
Yes, Your Honor. The defendant has a criminal history. From 2010, trespass adjudication was withheld. In 2010, burglary of a conveyance unoccupied, resisting without violence, and petty theft that were all dropped. 2011, 2 counts of battery that were declined based upon 2012, possession of tobacco product under 18, and 2012, possession of cannabis, adjudication withheld. 2013, possession of cannabis, adjudication withheld. 2013, possession of LSD. There was no dispo. 2013, possession of cannabis, adjudication withheld. 2015, possession of controlled substance, adjudication withheld. Based upon that, the prior batteries that were declined and the nature of the offense, the state would ask for a $5,000 bond, no victim contact, and an ankle monitor with pretrial.
Judge, Mr. Blake indicated he does have a job. Do you have a place? And he does have a residence where he can live, not with the alleged victim. I don't know if you consider anything less. He, like I said, he does have a job and he does have a place to live. Do you consider maybe 1,000 on count 1 with pretrial?
Was he scanned? Was he screened?
Judge, he also has a pending misdemeanor possession of marijuana.
Was he bonded on that case when this was he bonded on that case when this case occurred?
That case, he was arrested on August 17th of 2015, but it was disposed of on September 28th of 2015.
What? What was the
To adjudication withheld.
Did he receive probation?
He received... Sorry, my computer's slow. I apologize.
Anyone know if he was on?
Judge, I believe it was a withholding court cost. I don't believe it was any probation.
I don't believe that there was anything.
All right, so there's no 94806 violation. All right, I'm gonna go ahead and set bond on count 1. Bond on count 2 is gonna remain as set. Bond on count 1, I'm gonna set in the amount of $5,000. No contact with the victim, direct or indirect. All right, next up I have Chad Lyons.
Judge, I think he's at North Broward. He's not here.
North Broward.
All right, Mr. Lyons, you're charged with burglary with an assault or battery, as well as battery of a domestic nature. Any argument as to probable cause?
No argument.
All right, court's going to find probable cause. Any argument as to bonds on either count, state?
One moment, Your Honor.
Judge, are you finding proof, evidence, presumption great or just probable cause?
Are you asking me to do that?
I'm not, I don't know. I think the person in the courtroom is the arguer of the probable cause or that. I don't know, Judge. I think we're just leaving it up to division. I don't know if you're considering holding him no bond or if the state's filed any request for no bond.
And Your Honor, it's a first-degree felony, but it's not charges of punishable by life felony. So I
Very
believe
bad as a PBL.
I have burglary with assault or battery. Okay. Well, based on the PC in front of me, I think that there is proof, evident, presumption great that he reached inside the window and struck the victim in on her arm, and she sustained lacerations which the police officer corroborated. So I asked the court to hold him out, no bond.
Judge, I would ask you to defer to the division, Judge.
Yeah, I'm going to defer to a division. I don't think it's a good idea that anybody unless the state has witnesses here, I don't think it's a good idea to be asking me to rely strictly on a probable cause affidavit, especially because it's essentially just hearsay. And there's case law that suggests that pretrial detention can't be based solely upon hearsay, although the Arthur case does say I can rely upon sworn statements, but those are usually statements directly coming from the victim. This is hearsay within hearsay. So I'm going to defer to the division on count 1. On count 2, he is entitled to a bond. I'm going to set bond on count 2 in the amount of $2,500. Count 1 will be deferred to division. He'll remain no bond. All right? No contact. And I am finding probable cause as to each count.
Good.
All right, thank you, Mr. Lyons. All right, next up I have Robin Lane.
Paul Ryan, Judge.
All right, Ms. Lane, you're here today charged with resisting an officer without violence or obstruction without violence. Any arguments to probable cause?
No argument.
All right, court's going to find probable cause as to bond. Bond is presently set in the amount of $100. Anything that is state looking for any modification?
No, Your Honor.
Offense?
Judge, I would ask Your Honor to release her ROR. Ms. Lane can't post bond. She lives in Portland with her mom. She started working at Wendy's. She's doing training. She's been living by
Is there any history?
Yes, Your Honor. She has a prior burg dwelling with a battery from 2012 and a prior petty theft from 2012.
All right, I'm just going to leave bond as set in the amount of $100. Thank you, Ms. Lane. All right, next I have Rafaela Bergamini.
North Carolina.
So I have to burn out to get out.
All right, Ms. Bergamini, you're here today for a violation of probation on case number 14-1422-MU10A. It does have a bond set by the division judge in the amount of $2,500.
Yes, Your Honor.
I'm going to just, at this time, just leave the warrant in place. She does have a hearing on December 3rd, 2015 at 10 a.m. All right, Ms. Bergamini, you'll be in court.
Is the bond still there?
Yeah, you can post $2,500 to get out, but you need to
Thank
be.
you so much.
But if you post bond, you need to be in court on December 3rd, 2015 at 10 a.m. Otherwise, the judge could issue a new warrant for you.
I understand. That's not a problem.
Okay.
Thank you.
Oh, yeah.
I got a bond on a VOP.
All right, next I have Katerina Ivankova.
Come up here.
Sign, receive, and destroy.
All right, Ms. Ivankova, you're here this morning charged with battery on a law enforcement officer, disorderly conduct, and resisting an officer with violence. Any argument as to probable cause?
No argument.
Judge, it's very unclear. The officer or whoever wrote the report said that officers were summoned to the club, but the person who's writing the report doesn't indicate that he was in police uniform or acting as a police officer or indicated he was a police officer. It's happened at a downtown bar. I don't know if he was doing an off-duty detail, perhaps plain clothes. It says that the defendant and her friends were asked to leave. It said police were summoned, but it doesn't indicate that the officer was in uniformed clothing and acting as a police officer. It's unclear, anyway.
Your Honor, pretrial doesn't know if the defendant speaks English. We were informed that he spoke only English.
Ms. Ivankova, to Ms. Strickland, have you been able to communicate with Ms. Ivankova?
Yes, Judge, she does. She is from the Czech Republic. She's here studying English. She's never been arrested before. I was able to communicate with her. I know we probably don't have a Czech interpreter, but she was able to basically discuss basic things with me, and I would ask if you would consider standard pretrial. I believe she's living with an American family at a school and studying English.
All right, well, let
I
me
think the
deal
other-
first with the probable cause issue. State any responses to the probable cause argument?
Other than the fact that she was in the process of being handcuffed while she slapped and punched the officer, I think that at that point she knew that he was a law enforcement officer acting in his duty.
Yeah, the court's going to find probable cause for each of the offenses. As to bonds,
You don't have to be a police officer to handcuff.
Your Honor, based on her ties to the community, I would ask for a $1,000 bond on count 1 and 3.
Ms. Strickland, as to bond,
Judge, the state is asking for a $1,000 bond.
for each per count, for 1 and 3, and leaving bond at 100 on the disorderly.
Judge, I would ask if you make it a total of 1,000. I believe that she would be able to post that. As I said, she is staying with a family here, has no prior history. I mean, it did appear to be an altercation at a bar. I think one of the patrons did not get his credit card back, and they were trying to get his credit card back. So I was able to speak with her in that regard. I don't know if you consider something less than what the state's asking for.
All right, I'm going to go ahead and set bond on count 1, the amount of $1,000. Counts 2 and 3 will be ROR. There'll be standard pretrial release with the condition of no alcohol. So no more drinking while she's learning English.
Okay, Judge.
All right?
Ryan, Chad.
All right, next up I have Jessica Bonet. Good morning, Ms. Bonet. You're here today for a violation of probation on case number 13-12885 CF 10A. It is a no bond warrant signed by a division judge. I'm going to go ahead and hold you on the warrant. You do have a hearing set December 2nd at 8:45 a.m.
December 2nd. So I can be over here with you.
All right, next up I have Crystal Gray. Sorry. All right, Ms. Gray, you're here this morning charged with possession of cocaine, possession of cannabis, license plate, and drug paraphernalia. The only charge which has a bond attached to it is the possession of cocaine. Any argument as to probable cause?
No argument, Judge.
All right, court's going to find probable cause. Any argument as to bond, state, any reason not to leave the bond as set?
Your Honor, she does have a criminal history from 2006 of possession of cocaine and paraphernalia, and 2009 of possession of oxycodone. Based on that, I think that an increase in bond would be appropriate.
Anything from the defense?
Judge, I would argue to remove the bond as it is. Also, Judge, I would ask for a mental health screen for Ms. Gray.
All right, I'll order a mental health screen.
Judge, I don't know if the state indicated that she has a pending felony charge.
Oh, she does? We look that up and see if she was out on bond at the time.
Sure, Your Honor. Yes, Your Honor, she was arrested on November 24th, 2015. The incident occurred on November 23rd of 2015, and she was out on bond at the time. The case is still unfiled.
What type of case?
Possession with intent to sell or manufacture.
What kind of bond did she post?
She posted. Well, the bond was set at $2,500. I gotta get some pics.
What's that case number?
Case number 15015 CF 10A.
15015.
150 CF 10A.
All right, at this time, pursuant to, as to the case on magistrates today, I'm going to leave bond as set, order a mental health screen. However, based upon the finding of probable cause that a new crime was committed while out on bond, The court's going to revoke bond as to case number 15015150 CF10A. It shall be held no bond on that case pending any further order of the division court. All right? Thank you, ma'am.
All right, you can go back in. Bowling, you want me next?
All right, next I have Michelle Bolin, or Bowlin.
North Broward.
Bowling.
Ms. Bolin, you're charged today with grand theft. Any argument as to probable cause? Our court's going to find probable cause. Bond is presently set at 1,000. State anything as to bond?
No, Your Honor.
Judge, I would ask, for Your Honor to release Ms. Boland or put her on pretrial. We can't post bond. She's a cleaning lady. She spends most of her money on cleaning products. She does have a house here in Philadelphia. Does raise her phone. Whom she's been living with for the past 5 years.
Any history, state?
1 minute, Your Honor. Yes, Your Honor. Petty theft in 2014, adjudication withheld. That's it.
That's it, just the one petty theft?
Yes, Your Honor.
All right, I'm going to ROR her with pretrial release.
It'll be there Monday, between 8 and noon. All right?
All right, Ms. Bolin, thank you, ma'am.
Thank you.
You'll be out today.
All right, next I have Simone Vincent.
That's her? Oh, North. Yes, you will be out tonight.
All right, Ms. Vincent, you're here today for allegedly passing or forging an altered bill or promissory note and grand theft. Any probable cause argument?
No, Judge.
All right, court's going to find probable cause as to bond, state.
Your Honor, I'm still looking up her criminal history. I don't have a criminal history. I don't know if pretrial has anything. The state would recommend a $1,000 bond.
There's currently set at $1,000 per count. Defense?
Judge, first I would ask for a mental health screen and also would ask for her to be ROR'd or placed on pretrial, based on no priors. Also, Judge, she was a mother. She's been living for our time for 10 years and she's moved on.
Pretrial, you have anything on her?
Only that we were not able to verify her address.
All right, I'll ROR her with pretrial, but they're going to have to confirm an address before she gets released. Yeah. Are you here on her behalf, ma'am?
Yes, I'm on mom.
Oh, okay. Why don't you come up here, ma'am?
You know her? Hold on.
Want to raise your right hand, ma'am?
You swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Please your name for the record and spell your last name.
Ava Greaves, Greaves.
How do you know Miss Vincent?
She's my daughter.
And would she be able to live with you?
Yes.
And then where would she be living then? What address?
6390 Northwest 11th Street, apartment 204, Sunrise, Florida 33313.
Any questions from the state?
No, Your Honor.
All right, thank you, ma'am. All right, I'm gonna go ahead, Miss Vincent, put you on pretrial release, but I am gonna order a mental health screen so that she'll have to be seen by a doctor. Okay. But she will be coming and living with you. Okay. Pretrial is gonna just probably call and just confirm that that's where she'll be living, and then she'll be released. Okay.
Okay.
Judge, is there paperwork at North Broward that can be given to Miss Vincent about where to report to pretrial?
She's holding it in her hand as we speak.
Okay, I can't see. Okay, thank you. I can't see them.
I know you can't. Thank you. Thank you, ma'am.
You're welcome.
All right, thank you, Miss Vincent. All right, next I have Tiffany Henrik.
North Broward.
All right, Miss Henrik, you're here today for a possession of cocaine and drug paraphernalia, as well as for a warrant fulfilling for a capias as to case 1510227 CF10A. Any argument as to probable cause for the new law violations? All right, court's going to find probable cause. As to count one, the possession of cocaine, any argument as to bond? Bond's presently set at $1,000.
No, Your Honor, she has no criminal history other than the other pending case.
Anything from the defense? She is being held no bond on the capias. All right, I'm going to go ahead and leave bond as to count one set at $1,000. She is being held no bond on the capias. She does have a status in front of the division on December 7th at 8:30 a.m. All right, thank you, ma'am.
Carol.
Right, next I have Carolyn Furlow.
North.
All right, Ms. Furlow, you're here today for a possession of heroin and possession of cocaine, as well as drug paraphernalia. Any argument as to probable cause?
No, Judge.
Our court's going to find probable cause as to bond. Bonds are presently set in the amount of $1,000, $1,000, and $100. State.
Your Honor, I'd recommend bond as set. She has one prior prostitution in 2014.
Defense.
Judge, I would first ask for a mental health screen. I would also ask for your honor to reduce bond or release her ROR. She does receive Social Security disability for the past 2 years. She's unable to post bond.
She indicated to pre-trial that she's first poster bond.
Ma'am, you want to go ahead and just post monetary bond instead of being under the thumb of the pretrial release officers?
I'd like to try to.
Okay. I'll go ahead and leave bond as set in the amount of $1,000, $1,000, and $100. Thank you, ma'am. I will order a mental health screen. All right, next I have Samantha Schneider.
North.
All right, good morning, Good morning, Ms. Schneider. You're here today for a violation of probation on case number 151135 MM30A, which you have been ROR'd on. However, you're also being held for warrants on case number 156638 CF10A. Those are no bond warrants. At this time, I'm just going to hold you on each of the warrants. You do have a status set before your division on December 7th at 8:30 a.m.
Your Honor, can I say one thing? I was supposed to go to my orientation for drug court, but I didn't go because I was in the hospital. And then I just found out that it, was supposed to, I didn't really realize what I was supposed to do. I thought I was just going to end up opting out because my lawyer said that if you don't go to your orientation, you opt out. And then I just was waiting on a regular court date. So I was not aware of that warrant. The misdemeanor was because I didn't finish a class. So that I was aware of, but not this.
All right, well, you're going to want to bring that to the attention of the issuing judge who can address it at the appropriate time. All right, make sure you have paperwork showing you were in the hospital. All right, for the meantime, though, ma'am, you're going to remain on the warrant, and you'll be before the judge on December 7th.
December what?
December 7th. You can ask your lawyer. If you have a lawyer, you can ask your lawyer to call earlier. Thank you, ma'am. All right, next up I have Ryan Filarski.
He's here, Judge.
Hello, good afternoon, Your Honor.
Good afternoon, Mr. Filarski. You're here today on a warrant on case number 152647MO20A. Bond is set in the amount of $50 on the warrant. I'm just gonna, let's see.
Judge, Mr. Filarski asked me if he can resolve his case. I know we don't really represent people on the municipal ordinances, but if he wants to resolve it today, I don't know if the court would make a offer directly to Mr. Filarski.
I know that is there anyone here from the city? It's a municipal ordinance case. Anyone here from the city attorney or county attorney's office? No? Anyone present in the court have any idea of Mr. Filarski's history? No? All right, I'm hearing that there's no prior history and having no representation on behalf of the prosecuting entity.
Sorry, Your Honor. I do have a criminal history.
Do you have a history?
Yes, Your Honor. I have a battery upon a school employee from 2000. Adjudication was withheld. Burglary conveyance that was dropped. Tampering with evidence in 2002. Adjudication withheld. Possession of cannabis in 2003. Adjudication withheld. Disorderly conduct in 2013, adjudication withheld. 2015, burglary of an unoccupied conveyance. I don't have the disposition.
All right, if he wants to resolve this case today, the court's offer will be an adjudication, 5 days, Broward County Jail with credit for time served.
All right.
Do you want to resolve it for that? 5 days. We get credit for probably yesterday and today, so like 3 more days.
That'll work.
He said yes, Judge.
All right, Mr. Filarski, my understanding is that you want to plead either guilty or no contest, accept the court's offer of an adjudication, 5 days with credit for time served. Is that what you want to do today?
Yes, Your Honor.
All right, you want to raise your right hand? You swear to tell the truth, the whole truth, nothing but the truth?
Release Perry.
I swear to tell the truth, the whole truth, nothing but the truth.
All right, you understand that when you enter a plea, you're not going to have a jury trial. The state's not going to have to prove its case. You understand that?
Yes, sir.
You're giving up your right to be presumed innocent. You're giving up your right to remain silent. You understand that?
Yep.
You're giving up your right to appeal any matters other than the legality of my sentence. You understand?
Yes, sir.
If you're not a U.S. citizen, this plea will result in deportation. You understand that?
I do understand. I am an American citizen.
All right, do you need any time to discuss immigration with any attorney?
No, I'm not an immigrant. Born and raised here, 31 years.
All right, you understand that before you enter a plea, you do have the right to have an attorney and discuss this with an attorney. If you'd like some more time to discuss this with an attorney, I'd be happy to give you that time. You understand that?
No, Your Honor, I don't need the time. I didn't do anything wrong, so I'll just get it taken care of and over with as soon as possible.
Well, if you didn't do anything wrong and you want to fight the charges, you're entitled to do that. You understand that?
Yeah, but I don't have time for that. I got other things to tend to.
All right, so you understand if you plead.
Judge, I could just advise him that if he wants to have the benefit of counsel, it could be reset for tomorrow for magistrates when there are the city attorneys there. But it's up to him.
Yeah, Mr. Filarski, like I said, if you enter this plea today, I don't want that there be some later issue that you didn't have an attorney. I'll be happy to allow you to waive your right to counsel, but I want to make sure you don't have any questions.
No, that's going to prolong things. I need to be out by the second, so.
All right, well, you think it's in your best interest to do this then?
Yeah.
You have any other questions for the court?
Nope, none whatsoever.
All right, you want to plead guilty and say you did it, or you want to plead no contest and just not contest
No
the
contest.
charges? I'll accept your
No
contest.
contest.
I'll accept your no contest plea, find a knowing, intelligent, voluntary waiver of right. Predicate the plea upon the warrant and information provided to the court. This time, I'm just going to go ahead and adjudicate you, give you 5 days, Broward County Jail with credit for time served.
Okay. Thank you.
I'll waive court costs. Thank you, Mr. Filarski. All right, next up I have Daryl Armstrong.
North Broward.
For Armstrong? All right, Mr. Armstrong, you're here today for a DUI first offense as well as a DUI unlawful balance by a person under the age of 18, as well as some traffic tickets and a possession of cannabis and possession of open container. Any arguments to probable cause?
No.
All right, I'll go ahead and find probable cause as to bond. It's presently set at 500 on count 1, 1,000 on count 2. Pretrial has indicated a recommendation of pretrial state.
And the state would recommend bond as set, Your Honor.
Anything from the defense?
Judge, I would ask Your Honor to ROR him and place on pre-trial. He told him he's not working $1,000 a month, but 400 of those go to rent and 160 go to his car payment. He does live with an aunt for a lot of them, provide me an address.
All right, here's what I'm going to do. I'm going to leave bond on count 1 set at 500. Count 2 I'll ROR him on. I'm also going to add pretrial release with no alcohol. I'm going to add that to the order before I sign it. All right, thank you, sir. All right, next up I have Stephen Malone.
I work with a church for like 7 years.
Did you talk to pretrial this morning?
I haven't spoke to anybody yet, except for you.
All right, Mr. Malone, you're here today for a DUI first offense. Any argument as to probable cause? All right, the court will find probable cause. Bond is presently set at $500. Any argument as to bond from the state?
Your Honor, he has one prior possession of marijuana from 2002. Based upon that, the state would recommend bond as set.
Defense?
Judge, I would ask if you would consider standard pretrial. He does have employment. He does have a place to live. A minimal history. They said 2002 misdemeanor. The problem is with posting the bond is it's hard for him to get in touch with anybody. And he could afford it, but it's very hard for him to get in touch with anybody. I mean, I explained to him it would be easier to post a $500 bond than to be on pretrial, but he's just having difficulty making contact. And you can't make outgoing calls to cell phones in the jail unless they have their phones set up. So I don't know if the state or if pretrial screened him to see if he qualifies for standard pretrial.
Judge, he was interviewed, but not verified.
All right, I'm just going to leave Bondstead at 500 if he can afford it. I know it's difficult, but he's just going to have to get in touch with somebody.
Judge, I don't know if the public defender in the courtroom can do just a short order that he can have access to his cell phone in order to get telephone numbers. Maybe that would help him.
I'll sign that order.
Cell phone and my keys. My keys turn on my cell phone.
And his keys, because the keys turn on the cell phone?
I have to touch the back when my key won't turn on.
Maybe, I know they won't give him his keys or his cell phone, but I think they can, a deputy could watch while he does it, and he can just get some phone numbers out of
his. I'll sign an order giving him access to his cell phone if he can show them what he means by needing to be able to turn it on.
Yeah, it's just to push it on the back because it has a short, so I have to have the little round part of the metal of the key, and I push it, and it turns it on. And it's off. I know it'll turn right on. But without it, they're not going to be able to press the button. And I can't contact...
Is it any key, or is it your particular... Is it like a security feature?
It's the particular thing on... No, it's not a security feature. It's a short. There's a short on the back of my phone from dropping it in a puddle.
Right, so
I need to take this.
Wouldn't any piece of metal serve?
A good round piece, yes. I've done it with like a razor blade or like the back of my key. I touch it and it turns on.
Paperclip with a paperclip.
I just can't get in touch with anybody. I
understand.
I could
give you
afford to
access
pay
to your
this.
phone, but I don't know that they'll give you access to your keys. But if they could use one of their keys or a handcuff or something like that to click on
maybe
the phone,
I'll just turn it on. Yeah.
That should take care of the problem. So I'll give you access to the phone. Bond will remain as set. Thank you.
Okay.
Thank you.
Okay.
All right, next up I have Carlos Yelpi.
Judge, I believe we need a Spanish interpreter. Is there one in the courtroom?
Yes.
I wasn't able to really ask him about his ties to the community because he doesn't speak English.
All right, Madam Interpreter, you can
Good
raise
morning.
your right hand.
Good morning, Your Honor. Spanish interpreter present.
How much do you make at public?
I will. Luis Angela Lopez, LLP, EZ, Spanish interpreter for the courthouse.
All right, Mr. Yelpi, you're here today.
Señor Yelpi, usted está aquí hoy
Charged with driving under the influence.
por estar conduciendo bajo los efectos.
Is there any argument as to probable cause?
Pregunta si hay algún argumento en cuanto al motivo fundado. La abogada defensora dice que no.
The court's going to find probable
Perdón?
cause.
La corte encuentra motivo fundado para detenerlo.
As to bond, it's presently set at 500.
La fianza que han impuesto en este momento es de $500.
State,
State would recommend bond as set.
Vince,
Le pregunta al
He
señor.
indicated, I asked our interviewer if he could ask him if he could make a $500 bond, and he indicated you
Señor-
could make a $500 bond.
Señor, ¿puede usted pagar una fianza de $500?
Sí.
Yes.
all right, bond just remain as set.
Se impone la fianza que ya habían impuesto de $500.
Okay.
Ok,
Thank you.
gracias.
All right, next up I have Glenn Matthews.
Is it?
This is
That's it?
Glenn Matthews. Oh, he's coming up.
All right, Mr. Matthews, you're here today on a warrant for case number 151764MN40A. Bond is presently set at $500. Court's just going to hold you on the warrant with bond at the amount of $500. All right? Thank you.
Judge, would you consider an offer for time served to Mr. Matthews? He indicated that he missed court because he was in the hospital, and I told him he should have, brought in some paperwork about missing court, and he forgot. But he would like to resolve it if possible.
State is. I'm not going to make an offer from the bench without the victim having an opportunity to be notified that he intends to resolve. It's a theft case, so there's a victim. Unless the state
Okay.
is willing to accede to the court, I'm not just going to make an offer without the victim having a chance to be notified.
No, Your
State?
Honor. Your Honor, the state wouldn't be recommending the court to make an offer without knowing
All
whether
right,
there's
I'm not,
restitution.
Ms. Strickland, I'm not going to make an offer though because there's when there's a victim, the Constitution requires the victim to be notified.
Well, that is a victim. A Home Depot is a victim. Okay.
All right.
Okay, Judge, I'll explain that to him.
Thank you. All right, next I have Eric Fett or Fete.
North.
All right, Mr. Fete, you're here today for a municipal city ordinance violation for panhandling. Any argument? Well, I guess you guys don't handle that. Based upon the probable cause affidavit, the court is going to find probable cause. Bond is presently set in the amount of $25.
I spoke to him briefly and he indicated he wanted to resolve this case.
Mr. Fett, you want to try and get this case resolved?
Yes. I mean, is it, what time, is it time served today?
Well, I'm taking a look to see what your history is, and I'll make a decision based on your history. And State, you have any idea of a history here?
Your Honor, he does have a criminal history of mostly misdemeanors. I think all misdemeanor. 2002, possession of cannabis. 2002, possession of more than one Florida driver's license. 2002, possession of cannabis and paraphernalia and operating without a valid license. 2002, operating without a valid license. 2002, DWLS. 2005, DWLS. 2007.
How many of these type?
How many of these types of charges? 2007, 2 possession of cannabis is petty theft in 2007.
Not drug charges, but like panhandling, loitering, trespass, those kinds of things.
Your Honor, the only of those type are 2009 petty theft, 2009 trespass, 2009 trespass, and 2008 burglary of an unoccupied conveyance adjudicated guilty. 2010 loitering and prowling, sleeping on a beach on 2011, which was an MO. 2014 mental health court felony. That's all I have.
All right, Mr. Fett, if you want to resolve your case today, I'll adjudicate you, give you 3 days Broward County Jail with credit for time served. So you probably got 2 days credit. You probably have to finish out another day if you want to take my offer.
I'll just bond out.
Okay.
How much is bond?
$25.
Thank you.
All right, bond will remain as set. All right, next I have Lewis Gilbert.
North Broward.
Hi, Mr. Gilbert. You're here today for a warrant on case number 15825MM20A. Bond is set on the warrant in the amount of $500. I'm just going to hold you on the warrant, and you can appear before the division. All right. Thank you, sir. All right. Next, I have Jeremy Montgomery.
That's me.
All right, Mr. Montgomery, you're here today for a battery. That's also for disorderly intoxication. Any argument as to probable cause?
No, Judge.
All right, court's going to find probable cause. Bond is presently set at $1,000. No bond necessary on count 2. State, anything as to bond?
Your Honor, he does have juvenile priors that are direct related, and he has a prior from 2002 of battery on a firefighter, which is adjudicated guilty, and 2007 criminal mischief.
Strickland, anything as to bond? I can't hear you. You got it off.
Sorry. I didn't hear the state. I think they said they had juvenile priors. I mean, he's 38 years old. I don't know if you'd consider reducing the bond.
Well, what's his financial circumstances where it ties to the community? I think he had a 2009 battery on a firefighter.
That was 2002, Your Honor.
2002.
Judge, he's currently on SSI. I don't believe he has a lot of means. I don't know if you consider $250 bond.
Otherwise, is pretrial screening for acceptability to pretrial?
No, Rich.
Your Honor, to place him on pretrial, he will supervise the case. He was verified by his mother.
Is there a bond amount that he can make?
I can make 100.
$100?
10%, I mean.
Well, can he make? You can do $100 on 1,000.
Yes, sir. I get my SSI on the first, my debit card's in my wallet.
So if I left it at 1,000, you have the financial means to post the 10%.
Well, it says he'd still have to have a bondsman that's willing to.
Well, that's true, but that's not.
I mean, could you do? Let me ask him if he could do a $100 cash bond on December 1st.
Yes.
Could you do a $100 cash bond on December 1st, which he says that he'll have the money in his account and his debit card is in his property?
No, I'm not just going to do a $100 bond. I would leave it at 1,000, or I would do it, or I'd do pretrial release with some conditions. But if
I don't know if pretrial release is able to afford any address, able to verify any address.
Yeah, they spoke to his mother.
Oh, okay.
But, Your Honor, it's not certain whether or not he can live with his mother.
Oh, I misunderstood you then. Okay. Yeah, pretrial's not. I'm sorry, I misunderstood. Pretrial's.
That's what I was afraid of. Yeah.
At this point, I'm just going to leave bond as set.
Yes, sir.
Okay.
Okay.
Thank you, sir.
Thank you. Next, I have Caesar Gorezalaya.
Judge, he requires the interpreter as well.
All right.
Spanish interpreter present, Your Honor.
All right, Mr. Gorezalaya, you're charged today with trespass.
Señor Garay Celaya, a usted lo acusan de estar en un lugar sin autorización.
Any argument as to probable cause?
Pregunta a la abogada defensora si hay algún argumento de motivo fundado.
All right, court's going to find probable cause.
La corte encuentra motivo fundado.
Bond is presently set at 100. State, anything from the state is
La
bond?
fianza en la actualidad le han impuesto de $100.
Your Honor, he does have an extensive criminal history from relating back to 2009. I understand that the charges are trespass, but he has a 2009 operating without a valid license, 2011 assault on a law enforcement officer, 2012 possession of cannabis, 2013 trespass, 2013 trespass, 2014 resisting without violence, trespass, and disorderly conduct. Based upon that, I think that an increasing bond would be appropriate.
Señor Celaya, el señor juez le ha preguntado a la señora
It would
fiscal
be appropriate. I think that he has no ties to the community.
es el historial, los antecedentes que tiene usted. Dice que tiene un historial penal bastante largo desde el 2009. En el 2011 lo acusaron de no tener licencia válida, en el 2012 de posesión de cannabis, en el 2013 de estar en un lugar sin autorización, en el 2014 de oponerse a la policía sin violencia. La señora fiscal pide que le impongan una fianza sustancial.
Strickland, anything else as to bond?
Would the court consider making an offer to Mr. Garazalea? He said he would like to resolve it if possible today.
No, I'm not going to make an offer. He's trespassed on the same property, at least based on the 3C, twice, maybe 3 times. So I'm not going to make him an offer today.
La señora abogada allá presente le pide al señor juez que si puede resolver el caso, que usted le ha pedido que usted quiere resolver el caso. El señor juez dice que no le va a permitir que resuelva el caso en este momento porque tiene por lo menos 2 antecedentes anteriores de estar en el mismo lugar sin autorización. Y la fianza permanece como la han impuesto.
Anything else as to bond, Ms. Strickland?
No, Judge.
All right, bonds remain as set.
Él le pregunta a la señora abogada si quiere decir algo más acerca de la fianza y dice que no, entonces el monto de la fianza permanece el mismo.
Thank you.
Gracias.
All right, next I have Joseph Albert. All right, Mr. Albert, you're charged with battery as well as disorderly intoxication. Any argument as to probable cause?
No, Judge.
All right, court's going to find probable cause. Bond, state, anything as to bond? Bond's presently set at $1,000 on count one.
Your Honor, he does have a criminal history of disorderly conduct in 2007, resisting without violence in 2007, and trespass in 2007. And he also has a criminal mischief of 2008, and lastly, a petty theft from 2008. And sorry, one more, 2009 possession of oxycodone. Based on that, I think that a increase in bond would be appropriate to at least $1,500.
Benz?
Judge, I was actually going to ask if, I know he was talking to pretrial when I came in this morning. Were they able to?
Santana, Adrian.
He has a pending felony charge. You want to look that up, state? We'll see if he was out on bond.
Yes, Your Honor. His pending possession of alprazolam is in front of Judge Uson. It occurred on, the arrest paperwork was from November 8th of 2015. He was released and bond was posted on November 12th of 2015.
What's that case number?
Case number 15014-518 CF10A.
Judge, he indicates to me he's currently in a treatment center and that he can go back to. I would ask that you not revoke his bond on the alprazolam for the misdemeanor. If he needs to bond out, I understand that, but I'd ask that you not hold him no bond on the alprazolam. It says he was going to a treatment center in Sunrise.
Sunrise Treatment Center, right behind the mobile gas station.
All right, here's what I'm going to do. I'm not going to revoke his bond on that case, but based upon the allegations, as well as the fact that he was out on bond on another case when he picked up this case allegedly, I am going to increase bond to $1,500. And the state can file a motion if they wish on the other case and let Judge Uson deal with it. All right? Thank you.
Thank you, Judge.
Next I have Jose Utimo.
Judge, he also requires the interpreter. Thank you.
Spanish interpreter present.
All right, Mr. Utimo, you are charged with petty theft.
Señor Eutimo, a usted lo acusan de hurto menos cuantioso.
Any arguments for probable cause?
No, Judge.
Pregunta a la abogada defensora si tiene algún argumento en cuanto al motivo fundado y dice que no.
All right, court's going to find probable cause.
La Corte encuentra motivo fundado para detenerlo.
Bond is presently set in the amount of $25. State.
La fianza que le han impuesto hasta ahora es de $25.
The state would recommend bond as set.
La fiscal también recomienda que se le imponga una fianza de $25.
Defense.
Judge, he says he does have the $25 in his property. Would he be able to have access to his property so that he can post the $25 bond?
Yeah, I'll sign an order giving him access to property so he could acquire funds to post bond.
La señora abogada defensora allá presente le pide al señor juez permiso para que usted tenga acceso a su propiedad para sacar el dinero para pagar la fianza y el señor juez dice que va a firmar la orden.
All right, bond will remain as set.
Understand?
Se impone una fianza como se ha impuesto anteriormente que es de $25.
All right, next I have Emmanuel Razobara.
He bonded, Judge, they told me.
All right. Next I have Brian Thorpe.
Mr. Thorpe is present, Judge.
All right, Mr. Thorpe, you're here today on two capiases for different cases. One is on case number 002649 MF10A with bond set in the amount of $250. The other is on case number 0095431 TC30A with bond in the amount of $500. I am just going to hold you on the warrants. You do have a hearing in front of your division on December 3rd at 2 p.m.
Judge, would you consider allowing him to resolve them? They're 15 years old. I asked him where he's been for 15 years. He says, I guess he didn't know about them, or.
One's for a possession of cannabis, one's for a driver's license suspension. I mean, if I adjudicate him, he's going to lose his right to have a driver's license.
I explained that.
I don't need a driver's license.
He says he doesn't need a driver's license, Judge.
I don't want to drive.
Or you could withhold on the cannabis. Therefore, he wouldn't be.
I just want to give him the heads up because I haven't made him an offer yet.
I understand.
That's fine.
State, what's your position?
Well, Your Honor, based upon the fact that he's absconded for that amount of time, I think that he should be adjudicated. I don't have any criminal history, though.
You don't have a what?
I don't have any criminal history.
Zero criminal history?
I don't have anything. I don't know if pretrial does.
Pretrial, anything on him for criminal history purposes? No criminal history? All right, here's what I would do. On the cannabis, I'd withhold. Give him court costs. On the driver's license suspension, I'd adjudicate him. Give him 3 days Broward County Jail with credit for any time served.
Okay, Judge, he wants to do that.
All right, so Mr. Thorpe, you want to raise your right hand? Swear to tell the truth, holds you nothing but the truth?
Yeah.
All right, Mr. Thorpe, it's my understanding you want to plead either guilty or no contest to each of these cases, resolve them pursuant to the state court's offer, which as to the possession of cannabis will be a withheld in court cost, and as to the driver's license suspension would be an adjudication 3 days Broward County Jail with credit for time served. That's what we want to do?
Yeah.
You understand, sir, that when you enter a plea, you're not going to have a jury trial. The state's not going to have to prove its case. You understand that? You're giving up your right to the presumption of innocence, the right to remain silent. You understand that?
Yeah.
If you're not a U.S.
And
citizen,
to louder, he's hard to hear.
Yeah.
if you're not a U.S. citizen, these pleas will result in deportation. You understand that?
Yeah.
You need any more time to discuss immigration with your attorney?
No.
All right, the adjudication on the driving while license suspended, that could screw up your opportunity to get a driver's license at some point. You understand that?
Yes.
And you still want to proceed?
Yes.
All right, you have any other questions, Mr. Thorpe?
No. No.
All right, court having reviewed the reports, the court does find a factual basis for the plea as to each case. Mr. Thorpe, as to the possession of cannabis case, how do you want to plead, guilty or no contest?
Guilty.
I'll accept your guilty plea, find a knowing, intelligent, voluntary waiver of
Yeah,
right.
guilty when I got caught with it.
I'll withheld, give you court costs. As to the driving while license suspended charge, how do you want to plead, guilty or no contest?
No contest.
All right, I'll accept your no contest plea on that count, find a knowing, intelligent, voluntary waiver of right. I'll adjudicate you, sentence you to 3 days Broward County Jail, and credit for time served on that case, all right?
Okay, thank you, Judge. All right.
On which case? On the TC case? So that's an adjudication, 3 days Broward County Jail. Yeah.
Is this Thorpe, Judge?
Yeah.
3 days on count 2?
Yeah. Withholding court costs on one. All right, next I have Carlos Gisteo.
Judge.
I'm sorry?
He bonded.
All right.
He bonded out.
Gotcha. All right, Henry Knox.
Johnson Thornton.
Yeah, he also was Cadence.
Well, you man, you're a lawyer.
All right, Mr. Knox, you're here today charged with possession of cannabis as well as a capias on case number 151492 MM30A. Any argument as to probable cause? Well, it doesn't matter.
No, Your Honor.
He's a passenger, right? So he doesn't have standing to contest the stop as the passenger. All right, court's going to find probable cause. Anything as to count one bond, state?
Yeah, he has an extensive criminal history from dating back to 1991 of delivery of cocaine and possession of cocaine, to 1993 selling a controlled substance, 1993 grand theft, 1994 possession of cocaine, 1994 battery on a law enforcement officer, 1994 possession of cocaine, 1998 aggravated assault, 2004 grand theft, operating without a valid license. More recently, 2015 possession of cannabis, 2012 DWLS. Based upon his criminal history, the state would recommend an increase in bond to like $500.
Defense?
Judge, he indicated to me that he has a 9-year-old son. I understand he does have criminal history, although from what I was hearing, at least the felonies are over 10 years old. I understand he does have a cannabis now, but I would ask that you not increase the bond. If anything, I was going to ask that you reduce the bond. He does have a job. He does have a 9-year-old son who just had a birthday today. Today. So he missed his son's birthday today. I don't know if you'd consider an ROR or reducing the bond. I don't know if you can even.
I'm just going to leave bond as set.
Okay.
Thank you. All right, next I have Ezekiel Lemos.
What's your name again? Lemos? Oh.
Mr. Lemos, you're here today for a driving while license suspended arrest. You're also here for a writ. Looks like for failure to pay child custody would be my guess. Although, you know what? Let me look at it. Oh no, it's a civil arrest warrant for.
You know what that's for? It is child support, I believe, Judge.
Yeah, it is. It is. Any argument as to probable cause on the driving offense? Court's going to find probable cause. Any argument as to bond on the driving offense?
No, Your Honor, the state would recommend bond as set.
Offense?
He's unable to post the bond. I explained to him that you can't lower the 1,100. That's something that's a civil writ, correct? There's nothing that can be lower. He'd have to go in front of the.
Yeah, it's a purge. It's like it's a civil contempt. It's a purge. He can get out and he pays the $1,100. So.
But if he can't afford the $1,100, will he be taken in front of the civil judge so they can either come up with a payment plan or something? I mean, they can't just leave him in jail forever if he can't afford it.
Yes, at some point he'll be brought, and I don't know exactly when, how quickly it works, but yes, he'll be brought in front of the. He'll have the ability to be heard within 48 hours. So within 2 days, he'll get in front of the family court to address that matter.
Judge, would you consider an ROR on count 1, and then that way he just has to deal with the writ of arrest? It probably will get him at least to the civil judge quicker because it'll be the only thing keeping him in.
I did see that he had one prior misdemeanor. I don't know if pretrial has anything else.
Anything else on Mr. Lemos? All right, I'm going to ROR him on count 1.
He's going to ROR you on the driver's license.
How about Christian Cortez Rodriguez?
He bonded, Judge.
All right. And we'll find probable cause.
Last one.
All right, how about Rodolfo Ramirez?
Judge, I also need, yes, there we go.
Spanish interpreter present, Your Honor.
All right, Mr. Ramirez, you're charged with battery.
Señor Ramírez, lo acusan de agresión corporal.
Any probable cause argument?
Pregunta a la abogada defensora si tiene algún argumento y ella dice que no.
The court's going to find probable cause as to bond, state.
Your Honor, I don't have any criminal history. I don't know if pretrial does.
El señor juez le pregunta a la fiscal si tiene algún antecedente, dice que no encuentra antecedentes penales y el señor de los servicios especiales de la corte también dice que no encuentra antecedentes penales.
The state would recommend bond as set with pretrial and no victim contact.
Judge, Mr. Ramirez indicated to me that he has never been arrested before. He does have a place to live. I don't know if you would consider standard pretrial and no victim contact. I don't know if pretrial was able to interview him because he is Spanish speaking.
Does he live in the same apartment complex where the victim lives?
Señor Ramírez, la señora abogada ya presente le dice al señor juez que usted no lo han tenido anteriormente, que usted vive, señor, que le pregunta al señor juez si usted vive en el mismo complejo de apartamentos donde vive la víctima.
Mr. Ramirez did not understand, but what she was asking. You want me?
I want to know if I impose a no contact order and they live in the same apartment complex, that's going to make things difficult for him.
Señor,
I want to know if that's the case.
El señor juez dice que si él va a imponer una orden de no contacto con la víctima y usted vive en el mismo complejo de apartamentos que la víctima, va a ser un problema.
He indicated that the person does not live in the same apartment complex. I asked Mr. Herrera, our in-court public defender application person, to ask him the question.
Okay, that's fine. You working?
Señor, ¿trabaja usted?
Sí.
Yes.
What kind of work?
¿Qué clase de trabajo hace?
De una scrap metal.
¿Perdón?
De una compañía de scrap metal.
Scrap metal? He works in scrap metal.
Thank you.
All right, I'm going to go ahead. I'm going to reduce bond to $500.
Le reduzco la fianza a $500
Order no contact.
y ordeno que no tenga contacto con la víctima.
Okay. Thank you, Judge.
Thank you.
Gracias.
All right, next I have Davis Marin.
Mr. Marin also requires a Spanish interpreter. Judge, also, I was not able to speak with Mr. Marin at all this morning. The in-court deputies had indicated to me that he's on a suicide watch. I tried to talk to Mr. Marin with Mr. Herrera about, was he giving indication that he wanted to hurt himself, or was there some issue in the jail that was causing them to put him on suicide watch? And Mr. Marin said no, they keep harassing him.
Señor Marín, la intérprete está hablando. Señor Marín, la abogada defensora ya presente dice que ha tratado de hablar con usted a través del abogado que habla español allá y le han dicho a ella que usted lo están observando porque posible suicidio y usted dice que no es eso, que alguien lo está acosando.
All right, as to the Mr. Marin, you're here today charged with trespass.
Señor Marín, usted está aquí acusado hoy de estar en un lugar sin autorización.
Any arguments for probable cause?
Pregunta si hay argumento en cuanto al motivo fundado. Dicen los abogados que no.
Anything as to bond
El
state?
señor juez dice que encuentra motivo fundado.
Judge, I was going to ask you. Oh, sorry.
Hold on, let the state go. Go ahead.
He has one prior
Okay.
from 2013 of resisting without violence. I would defer to the court as to the bond.
Defense?
Judge, I was just going to ask if you'd either consider an ROR or perhaps allowing him to get time served. I don't think he has any criminal history other than what the state just indicated. I think it's a situation where he just doesn't really have a place to go and people don't want him.
Does he want to resolve?
Señor, la señora fiscal dice que usted tiene un antecedente penal en el 2013 de estar en un lugar sin autorización. A la señora abogada ya presente le pide al señor juez que si usted puede resolver su caso. Señor, ¿usted trabaja?
En el store de Big Mini, pero no todos los días.
I'm sorry, Your Honor, the interpreter was not able to hear correctly. ¿Qué dijo, señor?
En el store de Big Mini, pero no todos los días.
I work in the store. The interpreter did not understand the name of the store,
mini store.
but I don't work every day there.
Well, does he want to resolve his case, or would he rather fight his charges?
¿Quiere resolver su caso o prefiere pelear esas acusaciones?
Pues la verdad es que el tipo siempre me amenaza con pistola y yo siempre, el tipo no le caigo bien.
Well, yes, because what happens is I'm always being harassed with showing a pistol, but yes, I want to resolve it.
I'm not inclined to resolve it today.
Yo no voy a permitir que resuelva el caso hoy.
I'm concerned. Does he have a place to live?
Do you have a place?
Señor, ¿tiene usted un lugar donde vivir?
No.
No.
Vivo con unos amigos, pero no todos los días.
I live with some friends, but not every day.
I'm just going to leave bond as set.
Voy a dejar la fianza como la han impuesto.
Judge, would you consider maybe resetting the magistrate for tomorrow, like a second look docket, maybe ordering a mental health eval or something? I just don't want him sitting. He's not going to be able to post the $25. And I just don't want him sitting here for a week, 2 weeks, 3 weeks without going to court.
Señor, la señora abogada defensora ya presente le pide al señor juez que si por favor le permite que tengan el caso, pasen el caso para mañana para que lo vea el otro juez, puesto que usted no puede pagar esa fianza de $25 y no quiere que usted permanezca en la cárcel por una semana, 2, 3.
I'll go ahead. I'm going to go ahead. Even though I found probable cause, I am going to order a mental health screen.
Dice el señor juez que la señora abogada también le ha pedido al señor juez que a lo mejor sí le pueden hacer una evaluación psíquica y ordena al señor juez que le hagan una evaluación psíquica. Pardon me, Your Honor.
I'm going to ask you to put back on magistrate. He has not bonded.
Si usted no ha pagado la fianza de aquí al 1 de diciembre, el señor juez pone el caso para que lo vea el juez de la primera instancia.
For December 1st.
Para el 1 de diciembre.
AM.
En la mañana.
Okay?
¿De acuerdo?
Thank you, Mr. Marin.
Gracias, señor.
All right, next I have Levanta Smalls. All right, Mr. Smalls, you're here today for 2 municipal ordinance violations which do not require bonds, as well as possession of PVP, where bond is presently set at $1,000. Any argument as to probable cause?
No, Judge.
Our court's going to find probable cause. Any argument as to bond, state?
Your Honor, he does have a criminal history of exposure of sexual organs in 2013 and possession of clonazepam in 2014. The state would recommend bond as set.
Fence?
Judge, I don't know if you would consider an ROR for Mr. Smalls on the PVP, or also would you consider signing an order so he can get his phone, so he can get some phone numbers to make contact with family or friends?
The phone I don't have a problem with. I'm not gonna ROR him on the PVP.
Okay.
I'll leave
Another
all that
thing.
set.
Another thing.
thank you.
I got to
All right, next I have Casey Torres. All right, Mr. Torres, you're charged with 2 counts of burglary of an unoccupied dwelling, 1 count of grand theft auto. Any argument as to probable cause?
No, Judge.
All right, court's going to find probable cause. As to bond, state, as to counts 1 and 2.
Your Honor, the state would recommend a bond of at least like $3,500. He does have a related juvenile prior from 2013.
What was that for?
Burglary of an unoccupied dwelling and petty theft.
Okay. All right, defense as to bond on counts 1 and 2. Bond presently set at $1,000 on count 3.
So, I'm sorry, Judge, it's hard to read. 3,500 on each count, 1 and 2?
That's what the state's asking for.
Would you be able to? Judge, he's going to try to bond out on the,
All right,
if it's a total of 8,000.
Yeah, I'll set bond the amount of $3,500 per count for counts 1 and 2. Bond will remain as set on count 3.
Okay.
All right, next I have Tavares Grayhart.
You can try to get me on police at least with no.
All right, Mr. Grayhart, you're charged with aggravated fleeing with injury or damage, touching or striking police, looks like battery to a police. Maybe it's a police dog, I think, is what it's charged as. Resisting without violence, leaving the scene of a crash involving property damage, operating without a valid driver's license, and a license plate not attached. The only count for which bond would be required is count 1. But any argument as to probable cause?
No, Judge.
All right, court's going to find probable cause as to each offense. As to bond on count 1, state.
Your Honor, the state would recommend a $5,000 bond. He has a criminal history, juvenile criminal history that's pretty egregious.
Such as?
2008 murder and violence, 2008 robbery, residence, and accident, 2009 physical cancer, 2010 trespass, 2010 obstruction without violence and disorderly conduct.
Judge, I can't hear what the state attorney's saying.
Can you speak up a little bit?
2011.
2011, possession of cannabis. 2014, grand theft. Sorry.
All right. And you're looking for defense?
Judge, would you consider a bond of 1,000 on count 1 and with pretrial release?
No, I'm going to set bond the amount of $7,500 as to count 1.
You wouldn't consider anything lower, Judge?
No, not on these facts, not with that history. I mean, that's a terrible history for someone, a juvenile. Robberies, burglaries, violent crimes.
I ain't got no burglary. Say burglary. You got the wrong person.
He indicated he does not have any burglaries.
Were there burglaries or was it all robberies?
Robbery, sudden snatching, and then robbery, no weapon.
Oh, I'm sorry, they weren't burglaries. They were multiple robberies. So, even so, same thing. Same concern for the court. $7,500, thank you.
7,500 is the bond.
All right, how about Randolph Williams? All right, Mr. Williams, you're here today for robbery by sudden snatching and battery on a person 65 years or older. Is there any probable cause argument?
No, there's not.
Our court will find probable cause as to bond. State?
Your Honor. He has a criminal history that's juvenile. that's not that egregious, and his most recent criminal history is 2004 robbery, sudden snatching, and 2004 resisting without violence, 2005 possession of cocaine, 2005 possession of cannabis, 2006 robbery, no weapon. Ultimately, it pled out in 2007. End of record. Based on that and the charges in front of us, the state would recommend a $3,000 bond per count.
Spence?
Judge, hold on one second. The defendant's trying to say something. As to probable cause, I know that you already said probable cause, but Mr. Williams indicated to me that he was not identified, that he was not involved. Although it did say the co-defendants were detained, later charged accordingly. It says a show up, the victim identified the defendant, but he had indicated to me he was not identified.
Well, I have an affidavit that suggests otherwise. So I'm gonna find probable cause. As to bond,
High school playing the video.
How much bond can you make? Were you allegedly the dropper?
No.
Mr. Williams indicated to me that he cannot make very much bond. He has a place to live. He works landscape at Coral Springs Country Club. I don't think the allegation is that he was the person who did the robbery, nor was he the driver. I know it's a little. I'm just trying to read over the PC again. I don't know if the court would consider pretrial release on Mr. Williams.
well, his direct involvement in the PC suggests that while there was a struggle between the victim and the co-defendant, this defendant committed a battery upon the victim. So here's what I'm going to do. On the robbery, I'm going to set bond in the amount of $2,500. On the battery, I'm going to set bond in the amount of $3,500 for a total bond of $6,000.
Judge, I'm sorry, can you repeat the bond?
$2,500 on one, $3,500 on two. No contact with the victim, direct or indirect. All right, next I have Devontae Jones. All right, Mr. Jones, you're charged with one count of robbery, one count of by sudden snatching, one count of battery on a person 65 years or older. Any argument as to probable cause?
No, Judge.
I'm going to find probable cause. As to bond, state.
Your Honor, these are the same facts, but a lack of a record, and he is probably the more culpable of the co-defendants in the case. So the state would recommend the same bond as set before, with Mr. Williams as $2,500 on count one and $3,500 on count two.
Any argument, Ms. Strickland?
Judge, Mr. Jones is 19. He doesn't have any criminal history. He also does have a job. And like I said, he's never been arrested before. I don't know if the court would consider pretrial release or a lower bond.
Now I'm going to set bond on count one in the amount of $3,500, count two in the amount of $2,500. I'm just going to flip him from his co-defendant based upon the level of culpability based on probable cause affidavit, but they'll be the same amount total. No victim contact, direct or indirect. All right, Dontavius Spencer. All right, Mr. Spencer, you're here today charged with robbery by sudden snatching and battery on a person 65 or older. Any argument as to probable cause? All right, court's going to find probable cause. As to
Judge,
bond?
Judge, as to probable cause, I'm just a little confused. Both Williams and Mr. Spencer seem to indicate the same thing, that while allegedly Mr. Jones had done the robbery, Mr. Spencer and Mr. Williams committed a battery, but it's not really clear that it's like the same PC, but it doesn't say anybody by name.
No, I mean, the way I read, I agree, they're the same three PCs with different defendants listed. The way I read the PC is that while Mr. Jones was the individual that committed the robbery, that all three of the individuals participated in the battery in an effort to get away. That while there was a struggle going on between Jones and the victim, the other two co-defendants participated in the battery in an effort to try and get everyone gone. That's the way I read the PC. So that's why I'm finding probable cause, even though I do agree that all three PCs are essentially the same. That's the way the court is reading it. If there's some other facts that come out indicating some other version of events, then you can certainly raise that in division. But at this point, the court's going to find probable cause based upon the court's reading of the PC in all three cases.
Judge, as to Mr. Spencer, I would ask if you would consider a lower bond. He's never been arrested before. He does have a job. It is a little unclear, to me at least, what his participation was. I don't know if you'd consider a lower bond than the other two.
What's the state's position?
Yeah, he doesn't have a criminal history, but I don't think that, based upon the fact that he hasn't been arrested before, that his culpability is anything less than that of Mr. Williams. So I would recommend the same $2,500 bond on count 1 and $3,500 bond on count 2.
That's what I'm going to do. I'm going to set bond at $2,500 on count 1, $3,500 on count 2.
Total of 60.
No contact. All right, Lance Prevelholm. All right, Mr. Prevelholm, you're here today on a disorderly conduct as well as 2 violations on case number 13-11018 CF10A. The violations are no bond. Any arguments to probable cause on the disorderly conduct?
No.
Our court's going to find probable cause as disorderly conduct. Anything on bond as to count 1, state?
I just asked the court to leave it as set.
Defense?
No, Judge, I was just going to inquire, is this a 948 hold, or was there a warrant outstanding?
There was a warrant outstanding. It was signed November 12th by Judge Shearer.
Okay.
All right, so I'm going to go ahead and hold him on count 1 as bond as set. Counts 2 and 3 will just be held on the warrants. He does have a hearing before division on December 2nd at 8:45. All right, Malik Perry. All right, Mr. Perry, you're here today charged with 2 counts of burglary of an occupied conveyance. Any arguments as to probable cause?
No.
All right, court's going to find probable cause. As to bond, state?
Your Honor, the state would recommend somewhere around a $2,000 bond or more or per count because his criminal history, his juvenile criminal history, is all related.
2014 burglary with unoccupied dwelling and domestic burglary, tools, grand theft, and criminal mischief. 2014 murder and prowling. 2014 burglary with unoccupied dwelling and grand theft, 10,000 or 20,000. 2014 burglary with unoccupied dwelling and petty theft. 2015 burglary with a dwelling occupied and possession of burglary tools. And 2015 grand theft and murder.
You're looking for, I'm sorry, what was the number you were looking at?
Your Honor, I said at least a $2,000 bond, being that it's a third-degree felony.
Defense?
Is that 2,000 as each count, or
Yes,
1,000
2,000 as each count is what's being asked. A minimum of 2,000 each count is what's being asked for.
Judge, also, I believe his mother is present in the courtroom.
Yeah, I'll hear from her in a moment. Anything you want to say
Okay.
before I hear from...
Judge, he is part-time job delivering furniture. He is 18 years old. I don't know, his mother is present. I don't know if you would consider pretrial release or reduced bond.
All right, ma'am, you want to raise your right hand?
You swear that the testimony you are about to give us is true, the whole truth, and nothing but the truth?
Yes, I do.
State your name for the record and spell your last name.
Jessica de Gracia, Degracia.
All right, ma'am, is there anything you want to tell me concerning Mr. Well, what's your relationship to Mr. Perry?
I'm his mom.
Anything you want to tell me for the purpose of my consideration of a bond?
I just started working a week ago. I've been off work for 2.5 months. I can't afford the $2,000 apiece.
Well, you don't have to. I mean, he's a grown man. He can.
He
take care
just
of
turned
himself.
18 on August 29th.
Yeah. All right. Anything else you want to tell me?
I know the last charges that were just mentioned that have a 2015 date. Those were old charges that he just did time for at the beginning of the year. But this year, I mean, he's still in school. I was hoping I could have just got him out today so I can get him back in school tomorrow.
All right. Anything else?
No, sir.
Thank you, ma'am. Anything else, Ms. Strickland?
Judge, also the fact that he's in school, he goes to the, where did you go again?
Dave Thomas Education.
The Dave Thomas Educational Center, and I don't know if you consider pretrial release, maybe even like a house arrest pretrial release so he could go to school and work.
Judge, just to give you a time frame, the disposition for one of the burglary occupied was found. He pled out on April the 17th of this year. Then he was arrested on February the 12th of this year for the burglary and grand theft larceny. And we don't know if juvenile, if it's a juvenile hold or we have no disposition of that case.
Judge, he's done with everything. Probation, everything is done. Judge Ross just signed off on it about 3 weeks ago.
So he got all these other.
Everything is out of the way.
2 or 3 weeks ago.
Everything's done.
And then 2 or 3 weeks later, he's alleged to be snooping around, breaking into cars. Yeah, I'm going to set bond the amount of $2,500 per count. Thank you. All right, Larry Dean. All right, Mr. Dean, you're charged with aggravated assault with a deadly weapon without intent to kill. Any argument as to probable cause? Our court will find probable cause. As to bond, state.
One moment, Your Honor. His criminal history includes 2000 trespass and just misdemeanors, Your Honor. Based upon the facts and using a broken beer bottle. I'm sorry, I had the PCs mixed up. This was a small loaded handgun. The Jennings firearm, saying that he was going to shoot the victim, and asked the court to give a $2,000 bond with pretrial, no victim contact.
This would be a 3-year min-man case, right? Actual possession of a firearm and an aggravated assault?
If it's filed that way, yes, Your Honor.
All right, defense.
He has a prior arrest on the year 2004 for DUI, and it was a guilty plea.
Defense?
Judge, Mr. Dean just got a new job working at Publix, a very good job. He's going to try, he wants to try to keep that job. And I couldn't really hear, we're asking for a $2,000 bond?
With pretrial and no victim contact.
No victim contact, standard pretrial and $2,000 bond? Is that something you can make? Yes, Judge, that would be, he said he can make that.
All right, I'll go ahead and set bond monetarily in the amount of $2,000 without a condition of pretrial release no contact with the victim, direct or indirect, no firearms. So you can't own any firearms while you're on pretrial release or possess any firearms, Mr. Dean. All right?
Okay.
Thank you. All right, Mr. Rashid Labonte.
It says he's in North Broward, Judge.
All right, Mr. Labonte, you're here today for a violation of community control warrant, case number 13388 CF10A. I'm going to hold you on the warrant. You do have a hearing in front of your division on December 2nd at 8:30. Thank you, sir.
Okay.
All right, Tracy Hemphill.
Judge, if I may,
Hemphill.
I was called from North Broward asking if we could, go to page 25, the medical research for yesterday. They asked if we could call it down.
All right, let me just do Mr. Hemphill, and then we'll go back. We'll go to the medical resets, okay? So, Mr. Hemphill is at Maine. Mr. Hemphill, you're charged today with possession of cannabis with intent to sell or deliver, 2 counts of drug paraphernalia, 2 counts of resisting without violence. The only count that carries a bond is the possession with intent. Any argument as to probable cause, state?
No.
Excuse me, defense?
No argument.
All right. I'm of course going to find probable cause as to all offenses. As to bond on count 1, state?
Your Honor, he has a criminal history from 2008, trespass and resisting without violence. 2009, possession of cannabis. 2009, possession of cannabis with intent that was changed to delivery of cannabis for consideration, which adjudication was withheld. 2009, possession of cannabis. 2009, possession of cannabis with intent and resisting without violence, adjudicated guilty. 2010, possession of cannabis and trespass. 2010, delivery of cannabis, adjudicated guilty. 2010, possession of cannabis with intent to sell or deliver, adjudicated guilty. 2012, possession of cannabis within 1,000 feet of a church. The charge was changed to a misdemeanor, adjudicated guilty. 2012, possession of cannabis, adjudicated guilty. 2012, possession of cannabis, adjudicated guilty. 2012, delivery of cocaine, adjudicated guilty. 2012, delivery of cocaine, adjudicated guilty. 2013, loitering and prowling, adjudicated guilty. 2013, grand theft, adjudicated guilty. 2013, robbery, no weapon, adjudicated guilty. Your Honor, his criminal history is so extensive that I would ask the court to set a $5,000 bond.
Defense?
Judge, would you consider leaving the bond at 1,000?
No, I'm going to raise bond. I'm going to raise bond to $2,500. All right? Mr. Hemphill, with all that cannabis history, you're in the wrong state.
Yes, sir. I'm trying to clean myself up right now, and after this, I'm done.
$2,500 bond.
Okay.
I'm sorry? The other counts, they're not showing any bonds. There's no requirement to bonds on the other counts. Oh, wire bonds. Why does he not have standard bonds on the other counts? Hold on, Ms. Strickland.
Judge, would you consider, if your intent was to make it a $2,500 total, would you consider just RORs on the remaining counts? I was unclear as to that, if it meant he didn't have to pose a bond or you had to set a bond. Come back up, Mr. Hemphill.
Well, I shouldn't have to set a bond. They're not
Yeah.
magistrate offenses. Why are they not sure? Why was he not given just standard bonds on these?
Tracy.
They would have been like maybe $100. I don't know. But if you would consider just RORing them if your intent was to make it a $2,500 bond.
Yeah, I'll ROR him on the misdemeanors.
Okay. Thank you, Judge. It's okay. It's still the same. $2,500.
All right, Adrian Santana. Oh wait, I'm sorry. Can you have Mr. Santana have a seat?
Yes, Judge, on page 25 at North Broward, it's Victor Saavedra.
All right, I'm jumping ahead at the request of the Sheriff's Office to page 25, Victor Saavedra.
And Judge, he does require the
North Broward.
interpreter.
I'm sorry, Saavedra. Okay. Spanish interpreter present.
Mr. Bader, you're charged with driving while on a suspended license as a habitual traffic offender.
Señor Saavedra, lo acusan de estar conduciendo con una licencia que estaba suspendida y usted lo habían declarado un infractor reincidente.
Any probable cause argument?
No argument, Judge.
Pregunta si hay
Find probable cause.
algún argumento en cuanto al motivo fundado. El señor juez dice que encuentra motivo fundado y el señor del programa especial de la Corte, los servicios especiales de la Corte, dice que usted califica para los servicios especiales de la Corte.
What's the state's position on bond?
Un momento, Your Honor.
Un momento, señor, le pregunta a la fiscal qué decide ella en cuanto a la fianza.
The state would recommend bond as set. He has one prior soliciting for prostitution. Okay.
Vedra? Posted bond? Why is he in custody?
El señor está diciendo a la señora de las fianzas que a usted ya le han pagado la fianza.
Oh, okay.
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 All right. So that takes care of that.
Okay. Gracias.
Thank
Yeah,
you.
no problem.
Y el señor juez encuentra motivo fundado.
Okay, gracias.
Thank you. Was there another one
Thank
from?
you.
I believe that was it for that page, Judge, that actually names.
All right, let's go back then to Mr. Santana, Adrian Santana. All right, Mr. Santana, you're charged with grand theft and fraudulent or uttering a false instrument. Any arguments for probable cause?
No argument.
All right, court's going to find probable cause as to bond state.
The state would recommend an increase in bond. The defendant's criminal history includes unlawful possession of cocaine in 2005, criminal mischief 2005, grand theft 2006, trespass in 2006, trespass, resisting without violence, possession of paraphernalia, and possession of a controlled substance in 2007, resisting without violence in 2007, false name to Leo in 2008, petty theft in 2008, petty theft in 2008, petty theft in 2009, panhandling in 2009, panhandling in 2009. Your Honor, all these charges are somewhat related. His theft history is somewhat extensive, and the state would ask just for a slight increase in bond.
Defense?
Judge, Mr. Santana was requesting pretrial. He does have a job. He lives in Miami. I don't know if pretrial was able to verify any address, but he is requesting an ROR with pretrial release.
I don't have a phone. Based on the history, I'm going to deny that request. I'm going to leave bond as set at $1,000 per count.
Okay, thank you.
All right, Edward Smith. All right, Mr. Smith, you're charged with petty theft, as well as a violation of a capias for a warrant on case number 159158 CF10A. Any argument as to probable cause on the petty theft?
No argument.
All right, I'll find probable cause as to bond on the petty theft state.
The state would recommend you leave it as set.
Defense.
Judge, but you're saying he's being held no bond on the...
Yes, he's going to be held no bond on the warrant.
Okay.
The argument as to the bond on the petty theft?
No, Judge, I mean, he's going to have to go in front of Judge McCarthy. And if you'd like to ROR him on the petty theft, that might get him... Well, he already has a court date anyway on the PVP.
Yeah, I'm going to leave. I'm just going to leave bond as set. He does have a court date on December 2nd at 8:30 on the warrant.
Okay, thank you.
Thank you. Ronton Johnson. All right, Mr. Johnson, you're charged with 2 counts of possession of a weapon or ammunition by a convicted felon, 1 count of possession of cannabis, 1 count of driving with license suspended. Any argument as to probable cause?
No, Judge.
All right, court's going to find probable cause. As to bond on counts 1 and 2 needs to be set. Counts 3 and 4 are set at 100 and 750 respectively. State.
Your Honor, I'd ask pretrial for criminal history.
Pretrial and criminal history.
He has, in the year 2008, driving for license suspended, misdemeanor, no disposition, possession of marijuana in the year 2009, withheld adjudication, and that was a misdemeanor. And carrying a concealed firearm, misdemeanor, no disposition, possession of marijuana in the year 2011 in Dade County, misdemeanor without adjudication. In the year 2013, driving while licensed habitual, guilty. In the year 2000, July the 27th of this year, driving while license suspended in Dade County, and driving while license suspended with knowledge. It's not known if it's a misdemeanor offense or a felony offense, and that looks like that's pending on.
Where, in Dade or Broward?
In Dade County.
All right.
And it looks like he's wanted from Dade County for it. It looks like.
He has a warrant out of Dade County? I'm not showing a hold.
That's true, but it's wanted, confirmed, let me see where it comes from.
He may have a warrant out of Dade County.
Yeah, they issued the warrant, and the is
What kind of
the
vote?
31st, but it doesn't say what the charge is, but.
Judge, I can't hear anything.
August the 31st.
There was a warrant issued out of Miami-Dade for a case he has in Miami-Dade. Is it showing if there's a bond on that warrant?
No, nothing else, just wanted, that's all. No bond and nothing.
Yeah, I don't have any details on that, but apparently there's an active warrant out of Miami-Dade County.
Judge, if that's the case, I mean, he still, if he bonded out here, he could still go and deal with that. I don't know if they're holding him no bond or if there's a...
It's not showing it, but I don't know.
Judge, would you I couldn't really hear what pretrial was saying as to the priors, but Mr. Johnson does have a job. He works in Aventura at the Tommy Hilfiger. He's a lead stocker. It's a full-time job. The vehicle, although I know you can find probable cause, there were 2 occupants in the vehicle. I perused the PC. I didn't read it that carefully, but it appeared that there were 2 occupants. It is not Mr. Johnson's vehicle, and I don't believe there were any statements alleging that he knew of or possessed a gun. I don't know if you'd consider maybe $1,000 bond. And there was already a $750 at the count 4.
How's he getting? Well, I don't want him to answer this question, but most of his history is driving related, driving without a license.
Okay, Judge.
So if I put him on any conditions of pretrial, it's going to involve no driving. So I don't know how he's getting to and from work, but if he's driving without a license to and from work, he's just putting himself in a bad situation anyway.
Judge, he says that he can take a bus. He lives near the Aventura Mall, and if you make a condition of no driving, it appears he does need to get his license straightened out. He does have children. He does have a job. I mean, I know sometimes people just get in a situation with the driving where it's just like a hole he can't get out, dig himself out of. But if you would give him a low bond, make a condition of no driving, I mean, I know we can't guarantee, but...
Here's what I'm going to do. On counts 1 and 2, I'm going to set bond the amount of $2,500 per count. Counts 3 and 4, I'll ROR him on. I'll add a condition of pretrial release with no driving.
Judge, if he is on pretrial, is it okay for him to live in Dade County?
Pretrial can supervise in Dade County.
Okay. Standard pretrial? Okay.
Yeah.
All right. So it's 25...
That wanted is for traffic.
Yeah, he'll have to deal with that, the Dade County matter, separate and apart from this.
So, Judge, 2,500 count 1, 2,500 count 2, and then on count 4, you're still leaving a bond, or you ROR him?
ROR on 3 and 4, and then pretrial release with no driving as a condition.
Okay, thank you, Judge.
All right. Daryl Demps. All right, Mr. Demps, you're here today on a arrest for false identification given to law enforcement, resisting an officer without violence, possession of cannabis 20 grams or less. The only charge that has a bond on those three is the possession of cannabis, where bond is set at $100. However, you do have warrants, which are no bond, on case numbers 15-4214 CF10A, 14-12413 CF10A, 082331 CF10A, 067287 CF10A, 093578 CF10A, 092251 CF10A, 0021768 CF10A, and there's also a no bond hold from the U.S. Marshals for a federal matter. Any argument as to probable cause?
No, Judge.
All right, court's going to find probable cause. Any argument as to bond on count 3?
I'll defer to the court.
Anything from the defense?
Judge, we'll defer to the court. It appears he does have to just go in front of Judge Bailey and see what he could do about those.
Yeah, even then, he's still going to be held no bond for the feds, so he's got a marshal's hold. I'm just going to ROR him on the possession of cannabis, just to get that out of the way. Just to get that charge out of the way, and then he'll just go to felony court on December 2nd, 8:30 a.m. to address
There's
the
no bond needs to be posted on any of
violations.
those. Those are 0-0.
All right? Thank you.
Thank you, Judge. All right.
All right, Christian Gonzalez. All right, Mr. Gonzalez, you're here today on one count of possession of cannabis, 20 grams or less, one count of possession of alprazolam, one count of possession of lorazepam, one count of resisting without violence, and a trespass. Any argument as to probable cause?
No argument.
All right, court's going to find probable cause as to bond. State.
Your Honor, I'd recommend bond as set.
Spence.
Judge, Mr. Gonzalez, did the state say no prior felony history?
They just recommend bond as set. I didn't ask.
Okay.
It's not showing.
He has 2 pending felony charges? What case numbers?
151136 CF10A.
What are those?
Possession of alprazolam. 1513552 CF10A. Possession of alprazolam.
And was he bonded on both of those cases?
I'll look it up.
Yes, Your Honor. He bonded on case number 15011-360
What was that case number? 15011.
011360 CF10A. He was arrested on September 3rd, 2015 for possession of alprazolam and possession of cannabis, and he posted bond on September 8th of 2015.
Okay.
The case is still unfiled.
And then what's the other case?
The other case is case number 15013-552 CF10A. He was arrested on October 19th, 2015, and I'm showing he was released on November 20th.
All right, any other argument as to bond, Ms. Strickland?
Judge, Mr. Gonzalez indicated that his mother passed away a few days ago. He had said that he had gotten ROR'd on the cases. They're still unfiled. I don't know if you'd consider, he's working 2 jobs. He's got to take care of the house.
And I have an outpatient and a BART.
And he's also going to BARC outpatient.
Since I got ROR.
Since he was ROR'd on the previous cases.
I need to take care of my house.
All right, here's what I'm going to do. On the case before me, I'm going to leave bonds as set. At this point, pursuant to 94806, the court is going to revoke his bond on case numbers 15-11360 CF Tenay, 15-13552 CF Tenay. Order him into SAP, and then when he gets to division, he can revisit his bond with the division judge.
Judge, they're both still unfiled?
Well, it must be assigned to a division. He can still file a motion.
No, I'm asking the state. Those cases are both still unfiled, or is there a pending case?
They're both unfiled. One was in September, one was in November.
Okay.
What division are those assigned to? Just wondering.
What's that for?
Just sign up for the PD. They'll help you.
Sorry, I have so many windows.
Anybody know what division those are in?
Sorry, I just have to redo it. They're in front of Judge Shearer.
What division is that?
That's FJ.
All right, here's what I'm gonna do. I'm gonna ask that a status be set in Division FJ on all three of these cases for December 3rd, 2015.
Judge, would you consider pretrial after he completes the SAP program, or you
I'm
just
not
set
going
him
to
in front of
consider
Judge?
it. You can ask Judge Shear for it on December 3rd.
Oh, so you're putting a status December 3rd in front of Judge
Revoking
Shear.
his bonds
Okay.
on those other two cases today, ordering him into SAP, putting it for status on December 3rd, and Judge Shear can decide what she wants to do.
Okay, thank you.
Why can't I set a hearing? The magistrate sets hearing in my divisions all the time.
Judge, that's when they can talk about. I don't have any.
So there's no way I can set a hearing if it's not on the docket. I just revoke his bond and he just sits indefinitely until his PD contacts.
Judge, the attorney normally contacts the JPA for that judge and
You see, no one can just jump on Odyssey. I just want to be clear about this. We're in 2015. No one has access to a computer like my JA does, where they could just add a hearing onto Division FJ with putting in those two case numbers. No one from the clerk's office has the ability to do that in weekend magistrates. Is that what I'm being told?
Judge, only the docket clerk for that division can set it, but they definitely have to either have paperwork for it or get.
Well, I put it. It's right here. Here it is. I put it on my order. I put a status in Division FJ on 12/3/2015 at 9:00 a.m. So there's no reason it can't happen. There's no reason the clerk's office can't take this piece of paper with my order, and when they scan this in and enter my revocation of bond order on those two cases, that they can't just put a date into the computer. That would be utterly ridiculous if the clerk is unable to do that. Okay. I am ordering the clerk to set a hearing, and if the hearing is not set, I'll consider a rule to show cause against the clerk's office for the failure to comply with a court
Judge, I'll
order.
write it on the paper and send it.
Okay. That is utterly ridiculous. And if Ozzy or whoever's in charge of magistrates wants to give me a call, him and I are very familiar with each other. Okay, I'll do the same thing I told the clerk yet. The clerk and I are not friends. Okay?
Judge, before we move on, I have a question on Christian Gonzalez, the one you wanted to revoke the bond on.
Yes.
And this is just a question. He was just RR on the 21st because they did a delay, and they haven't filed the case.
I understand.
They did a delay. So you still want him brought back in?
Yeah, I'm revoking his pretrial release. That's what the if I find probable cause to believe that he violated his pretrial release, I can take him back into custody.
Okay.
And that's what I'm doing.
Okay.
Marvin Rivera.
Judge, we need a Spanish interpreter again.
Spanish interpreter present.
All right, Mr. Rivera, you're charged with DUI, first offense.
Señor Rivera, lo acusan de estar conduciendo bajo los efectos. Es el primer delito que comete.
DUI with property damage.
Lo acusan
or
de
person
de perpetrar daño a la propiedad o a una persona por estar conduciendo bajo los efectos.
resisting an officer without violence,
Lo acusan de poner resistencia a un agente de la policía sin violencia,
fleeing or attempting to elude law enforcement,
de fugarse o intentar eludir a un agente de la policía,
failure to render aid,
no cumplió con ofrecer ayuda,
operating without a valid driver's license,
operar un vehículo sin una licencia válida,
reckless driving,
de conducir temerariamente.
and there's a KPS case number 15-12210 CF10A.
Hay una orden de captura para el caso número 150122110 CF10A
For aggravated battery,
por causar agresión corporal agravada
which is no bond.
y no se puede imponer fianza para esta acusación.
Any argument as to probable cause?
Pregunta el señor juez a la señora abogada defensora si tiene un argumento en cuanto al motivo fundado. Dice que no. La corte encuentra motivo fundado para detenerlo.
Anything as to bond state?
Le pregunta a la fiscalía si tiene algo más en cuanto a la fianza.
I have one prior 2015 of operating without a valid license. Based on that, his continued driving and the charge of aggravated battery, the state would recommend on, I guess, count 8, a $3,500 bond and leave bond as
Okay,
set.
the aggravated battery, it's not. It's a no bond warrant.
I'm sorry, Your Honor, I thought it was a new charge.
Señor Rivera, la señora fiscal dice que usted tiene un antecedente penal en el 2015 de conducir sin una licencia válida, que usted continúa conduciendo y el señor juez la corrige en cuanto a la
But he is entitled
acusación.
to bond. It's not a failure to appear warrant. It's a not in custody KPS.
La orden de captura es usted no estaba bajo custodia.
Does it show that he's ever been magistrated on case number 15-12210 CF10A?
Pregunta si en algún momento le leyeron las acusaciones formalmente en la audiencia de primera instancia para ese caso de número 150122210
Never been even been arrested on,
CF10A,
right?
que no ni tampoco lo han detenido.
Courtroom for that?
No, what I have is well, hold on, maybe I do.
Momento,
Because I don't
señor.
have anything. I don't know if the in-court PD does.
Pregunta a la señora abogada si la señora abogada defensora aquí en la corte tiene algún argumento en cuanto al motivo fundado.
Yes, I do have a probable cause for that.
El señor juez dice que encuentra motivo fundado para detenerlo.
Here's my concern, though. I just want to be clear. The clerk's office has it showing on the magistrate form. Again, this is strictly as to 15-12210.
El señor juez dice que tiene una preocupación en cuanto al caso del 150122210 CF10A.
You have it on the clerk has the magistrate form listed as aggravated battery.
Lo que sucede es que los secretarios del tribunal tienen en ese informe para la audiencia de primera instancia que usted lo acusan de agresión corporal agravada.
But the KPS is for felony battery.
Pero la orden de captura es para una agresión corporal como delito grave.
My concern is if I set a bond on the KPS, which he's entitled to have,
Lo que me preocupa es que si yo impongo una fianza para ese caso que es delito grave,
and then the state changes the charge to aggravated battery,
y si la fiscal cambia la acusación a agresión corporal agravada,
which is another hold for magistrate offense,
es un delito que lo están manteniendo para traerlo a esa audiencia de primera instancia
based on the history of, or at least my history with the clerk's office,
y basado en el historial que tengo yo personalmente con los secretarios del
my
tribunal,
concern is that he'll then be, even though I set a bond on the KPS today,
porque la preocupación que tengo es que aunque yo imponga una fianza en esta acusación hoy,
the change of charge
el que cambien la acusación,
will result in his bond being reset at no bond,
la fianza que le habrían impuesto volverían a cambiarla y para que le impongan de nuevo una fianza.
And since the clerk has no policies or procedures in place to bring them back to magistrates,
Y
when
pues,
that happens,
puesto que las secretarias del tribunal no tienen una política en cuanto a cambiar esa fianza y volverlo a traer a la audiencia de primera instancia, usted simplemente permanecerá allá en la cárcel y le estarán quebrantando sus derechos civiles.
so how can we fix that now?
Judge, what if you
Entonces-
set the case? What if you just do an order with the case number and say that bond is currently set on the above case number, whether it's an aggravated battery or a felony battery at.
Yeah, I'd love to be able to say that, Ms. Strickland, but what's going to happen is the clerk and the jail will enter that bond amount pursuant to the charges listed on the capias.
Señor,
Felony battery.
la señora abogada defensora allá presente le dice al señor juez que
Well,
por
then
qué
maybe
no.
just ROR him on it.
I'm
It
sorry,
won't matter.
counsel. I'm sorry, counsel. Dice la señora abogada ya presente que le pide al señor juez que por qué no escribe una orden con el número de caso que diga cuál es la fianza, pero el señor juez dice que debido a lo que sucede con los agentes de allá de la
Love to say
cárcel,
that, I'm not going to ROR him on it, but I'd love to think that that would solve the problem.
Quisiera-
It still won't solve the problem.
quisiera
Right,
decir que no le impongo una fianza y que esto resolvería el problema, pero realmente esto no va a resolver el problema.
Because I've been told by the supervisor of the magistrate clerk's office,
Porque me ha dicho la supervisora de los secretarios
they don't
del
magistrate people on the same cases twice.
de las audiencias de primera instancia, que no a los acusados no les dan esa lectura de acusaciones por primera vez dos veces.
So if I
Judge, I understand your frustration. I'm going to talk to someone in my office about that because I know this week in court or last week you got frustrated with that same situation.
And you
but
can order the magistrate docket from yesterday because we had someone in that exact same circumstance.
Right, I know,
sit in
Mr.
custody
Ostel
for
told me.
2 weeks on a bondable offense because
Señor,
the clerk wouldn't send him to magistrate.
la señora
on the
abogada
second
está
time.
hablándole al señor juez y que le dice que entiende la frustración que él siente, puesto que ella también ha tenido ese mismo problema debido a que los secretarios del tribunal no pueden traer los
They
acusados de
contemplate
nuevo.
solving that problem as it pertains to count 8. Let's talk about counts 1 through 7.
Bueno, si ellos logran resolver ese problema en cuanto a la acusación número 8, hablemos de la acusación número 7.
As to the bondable counts, which are the DUIs,
En cuanto a las acusaciones que puede pagar fianza, el de fugarse o intentar eludir la policía o de conducir temerariamente. Y le pregunta a la fiscalía si ella tiene alguna sugerencia en cuanto a la fianza.
I'd ask the court to leave the bond as set and add the condition of pre-trial, possibly with an ankle monitor or some sort of testing. You know, he is continuing to drive under the influence, and he has a prior record of driving without a valid license from 2015.
Ms. Strickland, as to
La señora fiscal le dice al señor juez que ella pediría que dejen la fianza como la han impuesto, puesto que usted tiene un antecedente de estar conduciendo bajo los efectos. Si usted continúa conduciendo, le pediría que también lo ponga bajo ese sistema de los servicios especiales de la corte con un monitor en su tobillo, puesto que usted continúa conduciendo y tiene un antecedente del 2015.
Judge, would you consider pretrial release for Mr. Rivera? He has a job. He works construction. I don't believe he's able to post really any bond. If you wanted to do an ankle monitor, order no alcohol, or order a BARC evaluation. I'm not sure what bond you said you were going to set on the aggravated battery. I kind of got lost. I wasn't sure if you were set a bond or didn't.
Oh, we're going to get to
But
that
any-
in a minute. I have to set a bond.
Señor Rivera,
Set a bond that's enforceable in the event that the charge is changed.
Señora Rivera, la señora abogada ya presente le pide al señor juez si le puede dejar a usted en libertad bajo esos servicios especiales de la corte. Le dice que usted trabaja en construcción, que ella no cree que usted pueda pagar esa fianza y también que el señor juez puede ordenar una evaluación por el programa BARC. No sabe ella si el señor juez impuso una fianza. El señor juez dice que está tratando de hacer eso.
All right, here's what I'm going to do. On counts 1, 2, and 4, bond will remain as set for a total of $2,500. I'm going to add a condition of pretrial release level 2 with a GPS monitor. No driving, no alcohol.
El señor juez dice que va a dejar la fianza para las acusaciones 1, 2 y 4 permanecer como están, un total de $2,500 de fianza, y que añade que lo pongan en esos servicios especiales de la corte con un GPS y no puede conducir.
Right, so that's that case.
Eso para ese caso.
Now the other case, 15-12210 CF10A,
Para el caso de 15012210CF10A,
state showing that he's being held on that case.
le pregunta a la
What
fiscalía,
is the sheriff's office showing he's being held on that
le
case?
pregunta a los policías, los jefes de policía, a la señora representante,
Aggravated battery, right?
We're showing aggravated battery
¿qué es lo
because that's what the PC.
Right, that's what the PC says.
And then the KP is
What-
somehow ended up with felony battery.
Because it's
Right, because
filed
what
now.
happened is the state filed the charge as a felony battery instead of an aggravated battery. And here's what happened again. The clerk's office, even though this was issued back on September 21st, never communicated it over to the jail so the jail could change the charge from aggravated battery to felony battery, and so that he could then be magistrated when he was ultimately arrested on it, which was recently. So again, because the clerk's office screwed up the paperwork by not communicating the capias after this case was filed over to the jail, I would be setting a bond on an aggravated battery. Then he would get served with the felony battery capias, which would result in a no bond hold, again, and he wouldn't be brought back to magistrates, and he would sit no bond
el
in
señor juez le
violation
está
of his
pidiendo
rights.
a la señora representante de los jefes de la policía
Does this
que cómo
continue to
es
happen?
qué clase de acusación pusieron en ese reporte de la policía, y dicen que es
It's been 2 months since it's
agresión
not in
corporal
custody.
agravada, y la orden
not
de
aware that this
captura
existed for 2 months?
le pusieron como acusación agresión corporal como delito grave, y usted está allí desde el 21 de septiembre y no han puesto, no lo han traído a la secretaría para que ellos cambien esa acusación, porque la fiscalía ha puesto una acusación de agresión corporal como delito grave.
Issued by the clerk's office for the change of charge?
Debido a que los secretarios del tribunal
Exactly.
han cometido errores en los documentos, entonces él va a regresar a la audiencia de primera instancia, le van a poner otra fianza y usted se va a tener que quedar en la cárcel. Entonces, debido a este problema de que los secretarios del tribunal no están haciendo lo correcto, le van a volver a imponer no fianza.
I'm sorry. I can't hear what you're saying. I mean, the defendant probably doesn't even understand what she's saying, so I'd rather hear what you're saying.
Yeah, I'd rather Ms. Strickland hear this, because
I can't.
Some office other than me.
Did I know?
Has to. Here's what happened.
Fix it.
The jail had no idea that there was a felony battery capias, even though it was issued back in September. So when they arrested him, they arrested him on the PC, which was aggravated battery.
Right.
Let's just say I didn't pick up on it, or another judge was sitting in magistrates that doesn't have the same level of experience as I do with this particular problem. The judge would have set him a bond, as we're constitutionally required to do, on the aggravated battery. He would have then gone to post the bond on the aggravated battery, and lo and behold, the jail would say, wait a minute, he's got a no bond hold on this capias for felony battery, so now it's no bond. And he would say, wait a minute, but the judge just set me a bond. And the judge is going to say, oh, but the judge set you a bond on aggravated battery, not felony battery. And then what should happen is he should... My order's not going to matter, because
if it gets taken back to confinement status and it says that case 15-12210 is currently a felony battery and bond shall be set at $1,000 or $25, whatever.
I understand that, but what's the problem? The problem with that, Ms. Strickland, is that it's not going to show that this capias is ever served. That's what needs to happen, is that the jail needs to serve him with this not in custody capias, and that will then change out the charge. And then he should be going back to magistrate so that the bond can be reset. That is a terrible problem. It's a problem that's been brought to the clerk's office for the last year, and this particular problem has been brought to the clerk's office since the administrative order went into effect, changing these charges from standard bonds to hold for magistrates.
Your Honor, may the interpreter interpret.
Can you just go ahead and set a bond, and we'll just, we can't solve the world's problems today. I understand that.
All right, listen. You're going to have to pay attention. You're going to have to take notes on this one because what I'm setting him a bond on today is aggravated battery. And I promise you that when you next time you talk to him, you're going to look at the jail, you're going to look at the sheriff.org website or call the confinement status, and they're going to say, oh, it's not an aggravated battery anymore. It's a felony battery with a no bond hold. Mark this on the tape, wherever the tape is. Mark this, mark my words. And then order this and bring it down to Mr. Foreman's office. Because neither him, nor Ms. Seipel, nor Ms. Diaz, nor Ms. Joseph, nor anyone else I've talked to seems to give a damn about someone's civil rights.
Señor, el señor juez dice que él va a imponer una fianza en la acusación que él tiene aquí enfrente de él, agresión corporal agravada. Pero obviamente cuando los agentes de la policía vean esta información van a decir, no, pero si usted tiene una orden de captura en cuanto a que no puede pagar una fianza para salir de la cárcel debido a que tiene una acusación de agresión corporal como delito grave. Entonces, alguien va a tener que resolver ese asunto porque están quebrantando los derechos civiles de estas personas.
Let me ask this, State, what's the information on this case? Do you have access to Odyssey to look at the information?
I do, Your Honor.
Is the felony what's the underlying, what makes it a felony battery? Priors?
No,
Injury?
Injury, great bodily harm, permanent disability, or permanent disfigurement.
So I was going to come real close to finding no PC for aggravated battery under the argument that the state doesn't even think it's an aggravated battery. The state thinks it's a felony battery, and that's why they filed that as their charge. However, because both cases involve injury, I am going to find probable cause. But I'm not going to find probable cause for an aggravated battery. I am going to find probable cause for a felony battery.
Dice el señor juez que él no va a encontrar motivo fundado para detenerlo por la acusación de agresión corporal agravada. Lo que sí va a encontrar es motivo fundado para detenerlo en la acusación de agresión corporal como delito grave. Y a lo mejor esto pueda resolver el problema.
And I'm going to set bond on the felony battery in the amount of $2,500 with no contact.
Voy a imponer una fianza de $2,500 y no debe tener contacto o comunicación con la víctima.
And just to be clear, when the jail says, wait a minute, this is not a felony battery, this is an aggravated battery, that's when you're going to have to point out the fact that there's this not in custody capias that needs to be served, because that's what the court is actually setting the bond on.
Señor juez, le está indicando a la secretaria de los jefes de la policía que cuando vean esta información se den cuenta del problema que está sucediendo aquí para que lo corrijan.
All right, that's that. And Ms. Strickland, I trust that you'll bring this to the people that need to be brought to.
I was already bringing it to somebody's attention, but I'll bring it again.
And you can have anyone who's interested come meet with me, and I'll be happy to give them plenty of other
I
examples.
will, Judge. I know, it happens on like Bergbat, and then they file battery. I know, I've
It
seen it
happens on any
too.
change of charge that where the charge is changed to one of those hold for magistrate offenses, because then they shouldn't.
But they don't hold them for magistrate.
They just hit them with a no bond hold and just let them sit no bond.
I agree. I had an armed robbery. They filed grand theft while armed, and they were still held no bond, and it's a bondable offense.
They should be going back. As soon as that change of charge gets hit, they should be coming back to magistrates to have bond reset by the magistrate.
I agree, Judge. But that doesn't mean anything either. So.
The problem is the clerk's office doesn't seem to agree.
Well, the jail should have a issue with it too, because they have liability if people are held no bond. It shouldn't be.
The jail should have an issue, but it's not. The jail doesn't know it unless the clerk is
It gets
setting it
brought
on
to
their
their
magistrate list.
Mr. Roman. Okay.
If there's not a court date set, then COC comes to court. That's how it's
All right, Jonathan Roman.
Love, Mr. Roman. You say you can afford the $1,000 bond?
Go 100. All right, Mr. Roman, you're charged with grand theft and resisting recovery of property. Any argument as to probable cause?
No argument, Judge.
All right, court finds probable cause. Bond on count 1 is set at 1,000. State.
Your Honor, I don't have any criminal history. The state would defer to the court.
Defense.
Judge, I don't know. He does not have any criminal history. I don't know if you would consider an ROR or a reduced bond.
All ROR with pretrial release.
Dollar Tree currently?
Okay, ROR with standard pretrial release, Judge? Okay, thank you.
Thank you.
Is that one and two?
I don't think there's any bond required on 2. There's no charge as to 2. All right, Jonathan Canning. All right, Mr. Canning, you're charged with carrying a concealed firearm. Any arguments to probable cause?
Have any prior felonies?
No.
No? No prior felonies?
No.
And Burgess got in a fight with the guy before for lying to
I
me.
ain't got no felony.
Okay.
All right, court does find probable cause. As to bond, state.
Your Honor, the state would recommend bond as set. He does have criminal history, but they're juveniles.
What kind of juvenile offenses?
Battery, Your Honor, and aggravated assault.
How old are you?
24.
You turned it off, Ms. Strickland.
Sorry. Mr. Canning, he has no prior felony offenses. I know she said juvenile. He's currently 24 years old. I don't know if you would consider an ROR with pretrial.
He can't come up with 1,000?
He says he's unable to get in touch with anybody right now.
Nobody. If he can,
Does he have any family locally or anything? Or he can't get in touch because he doesn't have anybody?
He lives down here, but his family is in Orlando, and he's currently not able to get in touch with anybody.
Does he live in Orlando?
He does have a residence down here, but his family's still up in Orlando.
he's still on.
All right, I'll ROR him. Level 2 pretrial with the DPS. All right.
Okay, Judge. Thank you.
Thank you.
Here. This is where you got to go for pretrial, okay?
All right, Damian Baker.
Morning, sir.
Morning, Mr. Baker. You're charged with aggravated assault with a deadly weapon and possession of cannabis, 20 grams or less. Any arguments for probable cause? All right, court's going to find probable cause. As to bond on count 1, state.
Your Honor, the state would ask for an increase in bond. His criminal history includes...
Bond hasn't been set yet, so...
Well, I'm sorry.
Okay.
Then at least a $3,000 bond that on count 1. His criminal history includes robbery, 2 counts in 2002, grand theft auto and resisting without violence in 2002, 2005 grand theft, 2006 grand theft, 2006 conversion, which is theft related, 2006 grand theft auto, 2006 resisting without violence, and 2008 robbery by sudden snatching, 2010 petty theft, 2010 retail theft, 2010 petty theft, 2011 littering, 2011 retail theft, and 2011 theft, 2011 burglary of a structure, that was an old pros, 2011 petty theft, 2012 burglary of an unoccupied dwelling with assault or battery that was dropped, and 2012 trespass.
What are you looking for?
Sorry, Your Honor, I missed a few. 2012 felony petty thefts, 3 counts, and then another felony petty theft. Based on that, the state would recommend a $5,000 bond.
Spence?
Judge, I don't know if the state has the pending felony
What is that?
for possession of PVP.
What's that case number?
Judge,
151830 CF10A. 20 how's it 20 CF10A? Oh, I'm sorry. 1518.
There it goes.
151820 CF10A. 151380 CF10A. That's
and what's the
possession of
charge?
Possession of PVP. Did you bond on that case?
Nah.
ROR.
Alright.
Is that still unfiled?
Yes, Your Honor.
It's still unfiled?
Yes, Your Honor. The lab the state filed its notice of intent to delay on November 24th, and he was ROR based on that.
Okay, so it's still, unlike the last time, last time the case was filed.
Your Honor, he was arrested on October 26th. The lab is about
I know the
60 to 90 days behind,
I know.
so.
I understand that. All right, I'm not going to revoke his bond if the case remains unfiled. But what are you looking for bond on the aggravated assault?
No, you're gonna have to call him.
Strickland bond, what are you looking for?
Judge, would you consider like a $2,000 bond? He doesn't know if he's going to be able to get in touch with family. He is local. I don't know if you consider something there of 2,000.
Is he living at the same location where the victim is living?
No, that's a friend of my family.
Are you living at the same location?
No,
No, Judge.
The owners of the business is where I live.
I'm going to step on, with his history, I'm going to step on the amount of $5,000, order no contact with the victim, direct or indirect.
Okay.
Thank you. All right, Warren Sweeney. All right, Mr. Sweeney, you're here today for a petty theft. Any argument as to probable cause? No. Our court's going to find probable cause as to bond, state.
One moment, Your Honor. Your Honor, the state would recommend a $1,000 bond.
Defense?
Judge, Mr. Sweeney indicated that he does have a place to live, that he does work as a landscaper with garden groomers. I don't know if you'd consider a lower bond than the $750. Also, I can't tell from the docket, is this a misdemeanor or a felony?
Well, it's showing a misdemeanor.
You try to get ROR.
It says petty theft second degree, but then it says third
It's a felony
subsequent.
petty theft, Your Honor.
The felony?
When it's a third or subsequent offense.
Oh, yeah, it is. It's a
Judge,
felony.
I don't know if you consider
No, I'm going to leave bond
pre-trial
as,
release.
I'm going to leave bond as set.
$750 bond. He's not going to ROR you. I just asked him.
All right, thank you. All right, Joshua Johnson.
Medical reset, Your Honor.
All right, so reset for the AM docket tomorrow, November 30th. Who do you have there?
Judge, this is Scott Clark.
Ms.
It's
Lee,
a
it's all
recent
right.
ROR. Oh, I'm sorry. I thought you were asking me.
You got Scott. This is Scott Clark.
I have Scott Clark, page 28. I guess it was a probable cause perfection.
Yeah, 48 hours though.
Count.
From I guess Friday.
From Friday, yes. But it looks like it's just as to count 13 and 14.
Say your first name.
Quinn.
State any additional information as to counts 13 and 14?
Your Honor, I wasn't given any paperwork from Friday, only from yesterday, so no, I don't.
I would then ask that he be ROR'd to these counts. I mean, I think there are
At
counts
this point,
pending.
with no additional information, the court's going to ROR him as to counts 13 and 14. Find no probable cause.
That's just for those two counts, okay? Judge, there's also a Q-N Lee on the docket, but I don't have anybody else left here.
I think it's a female, so she's probably over in other facility.
Okay.
I know, it was from me yesterday. Ian Lee, is she in North Broward?
No, sir, she's at Paul Ryan right now.
Paul Ryan, thank you. All right, this was a 24-hour perfection yesterday. There was an issue as to whether or not this was an aggravated stalking based on the fact that there was no evidence of any kind of repeated efforts to violate the injunction. The statute for aggravated stalking requires that there be a willful, malicious, and repeated effort to a willful, malicious, and repeated course of conduct. The court yesterday had found that based upon the probable cause affidavit that there's no evidence that this was a repeated violation of the injunction, although it noted that there was an injunction and that there was at least one allegation of a violation of the injunction, but aggravated requires repeated. So anything from the state?
The state would just ask the court to find probable cause for the misdemeanor violation of injunction.
Anything from the defense as to that?
Judge, I don't know if there was a bond set yesterday, if you're only finding
No,
probable cause
I
on this.
didn't set bond. I gave 24 hours to perfect. There's been no perfection, so the court's going to find, unless there's an argument that there's no probable cause as to misdemeanor stalking just for violation of a restraining order.
Judge, I don't have any paperwork. I don't know if there's paperwork that the PD in court, Ms. El Nafi has. I don't have any paperwork.
Yeah, I'm not going to find PC as to aggravated. There's no evidence of repeated violation. However, there is evidence of a misdemeanor for violation of a restraining order. Is there any argument as to PC on that allegation? All right, so the court's going to find no probable cause as to aggravated stalking, but the court would find probable cause as to violation of a court order, or a violation of a restraining order. Give me a moment, I'll give you the statute number.
I believe it's 784.0487, subsection 4.
That's not, those are all the felony subsections. I don't even think it's within the stalking. Oh, here, it's violating, it's... It's 784.047. First degree misdemeanor. All right, and as to bond, as to that count, any history?
I don't have anything, Your Honor. The state would just ask for pretrial release and no victim contact.
But I would argue to ROR her based on no priors and based on the fact that she's now a
I'm not going to just straight ROR her, and the reason being is because she had a copy of the restraining order allegedly in the glove compartment of the car, and yet she still contact with the victim or was within range of the victim. So I'll release her. I'll ROR her with pretrial release. No contact with the victim. If she does have contact, she'll just be in violation of the restraining order again, and she'll be in violation of my court order. Alright?
Okay.
Anything
Are we
else
done?
needs to be addressed?
Yes, Your Honor. There was another perfection from yesterday.
Yeah, you have to take 48 hours though, so it's not going to be on the docket for tomorrow.
Okay, I'll leave it. Thank you.
Like, you need 48
On the guy with the felony felony, you set the 2,500 on that case. Is that with pretrial too?
I don't think so. There's no contact, but no, I don't think I wanted.
So you only put them on pretrial on the DUI?
Correct.
Because I have two medical reports from yesterday. I don't know if we can address them today.
I know we addressed at least one.
I have two left, and I made a note of yesterday.
Why are they not back on the docket today?
Pacheco.
One is for Pacheco Ibanez, another one's Lyons, Chad Lyons.
We did Chad Lyons.
We did Lions.
Okay. And then, so Pacheco Ibanez.
I don't know why that wasn't on the docket today. Maybe he's not back from medical. Maybe he's not back from medical. You might check and see.
This Olga Pacheco Ibanez.
Oh no, didn't we do that?
That's from yesterday. I don't.
The name rings a bell, but I may have been ringing a bell from yesterday.
Yeah, I don't think we did that today. She bonded.
Oh, okay. Listen, please don't take any personal offense to my rants on the clerk's office. It has nothing to do with the individual people that work in the clerk's office at your guys' level. I think you guys do a heck of a job considering the resources you're giving and the money you're taking. But I've raised these issues with your supervisors of various levels continuously for the last year and a half. No one seems interested to do anything. And that's what drives me crazy. I can appreciate there being a problem when someone tries to get the problem fixed and no one's willing to, or interested in fixing the problem. That's when it becomes a more significant problem to me. We can all make mistakes, but if we are not willing to make any efforts to fix our mistakes, that shows a complete misunderstanding of what your job is, and that troubles me substantially, especially when it comes to people sitting in custody. And actually, for the state's sake, it happens. I don't know if it happens. I'm sorry, I don't know if we've ever even before introduced, but
No.
what division are you?
Judge Bober.
I'm sure it happens when Judge Bober, where things don't get.
Have a nice day, everybody.
Quickly, or things don't make it. But trust me, I mean, when a case gets issued in court, it doesn't get entered into the system for 24 or 48 hours. For the state, that should be a significant problem.
It is.
And if you've ever taken a tour of the clerk's office and see how many stacks of papers are still just sitting there waiting to be entered into the system. All right, have a good rest of your weekend. Bye-bye, thank you. I'll go back to the board. Thanks.